Pernah. Yes. Item 7. Item 7. Taken up after 1 week. Post after 1 week.
Item 10, Milord.
Yes, sir.
Item 10, Milord.
Item 10. Yes, sir.
Yes, Milord. That I suggested that the company for withdrawal or that compromise, Milord, taken up after 10 days, Milord.
No, these two matters I am discharging from my office now.
That
Roaster is not there with me now.
yes, Milord. Yes, Milord. Yes, Milord.
These two matters, 9 and 10, post appropriate bench. Okay.
Much obliged, Milord.
With the Lordship's kind permission, my lord,
Yes.
this is Anantrao Advocate, my lord.
Yes, yes.
May I make a mention, my lord, with regard to a case which is not in the list.
Yes, sir.
My lord,
One second, sir. Item number?
not item number.
No, 1 second, sir. Item number 70.
I'm sorry. I'm
Okay.
sorry.
When do you want? The next week. Yes, sir. Tell me.
WP number 41
Corresponding 41
41870
41870.
by 2018, my lord.
Yes.
Pension matter, my lord.
Okay. Next week, sir. Next week.
Yes, my lord. Any date next week.
Next week.
Some date may be given, my lord.
Looking of two cases, one is case of lodging, my lord. BD has refused the case. But that also because the records are being adapted. Another case, my lord, searching are going on. Giving two cases.
Next week.
There are three cases, my lord.
So, Lordship, 2019 service matter, my lord. Petitioner is being discharged from his duties and not allowing to his duties, my lord.
Next week. Next week.
No matter.
2 weeks. Post after 2 weeks.
No matter, there's an urgency in this matter.
2019 matter. Yes, sir.
There's an urgency, my lord.
We have fixed 18 1 week, 19 2 weeks, 23 weeks. Yes.
Last filed review petition last by confirming the
Review petition. Who passed the order? This bench only?
last occasion Sanru court was passed by confirming the lower court tribunal award and recently the honorable apex court has awarded under no fault liability. Lordship, rupees 5 lakhs awarded, your lordship. due to that file review petition.
In that, can we file review?
Yeah.
What is meant by review? What is the meaning of review? If any mistakes occurred while passing the order, typographical or technical, then review will be made.
Apex court has
Altogether different you are asking. Apex court is, but at the time of the argument, you are not shown that this one, any judgment. Basing on available records and basing on your argument, we pass the order. Can we call it as review? Think over and come again next. Think over whether it is called review. Review means it's not review.
much all.
Next week. Next week. Next. Which year? Next week.
Lordship CRP 2020.
CRP?
2020.
Which district?
Vikarabad.
Next Friday.
Sorry.
Millard, may I make a mention, Millard?
1 second.
2000.
Item 14.
That's a deep one.
Why they are fighting in the court again? Both of you convention together, and you are telling this. What is this? I am not able to understand. This is the implementation of the contempt interim order, na? No, inform other side, huh? What they said? When do you want?
Next week.
Item 14,
15, 16.
15 and 16. The post after 2 weeks.
53 and 76.
Hmm?
76.
So, learned counsel for the respond and informed this court. Next week.
53 and 76.
53. This is also related, huh? 53 and
60 and 76.
next week.
Next week. Right.
No, why they are doing like this? I think yesterday you have seen fighting. That is the condition of the attitude of the advocate. We won't how to believe the urgency of the cases. One way they are telling urgency, getting interim order, not implementing, again they are granting, and they are taking time, they are accepting. Okay.
May I please, Millard? 2019 matter, Millard.
Can you permit me withdraw, Miller?
What do you want, sir?
Kindly give me permission for mentioning Millard. 2019 matter.
Mentioning,
Mentioning Millard.
what is the urgency?
Since 5 years, this matter is still in admission stage only, Millard. The petitioner is jobless since 5 years.
What is he?
He is a professor in a private engineering college.
How it is maintainable?
As per the AP Education Act, Millard.
Private institution professor eligible to fight a
Eligible, Millard. Eligible. Very much eligible, Millard. As per the Act. 2019 matter.
Post after 2 weeks. Number చెప్పండి ఒకసారి.
WP 23200 of 19.
19. Post after 2 weeks.
Apply.
Withdrawal. First one is withdrawal. Letter is there. Okay. Basing on the letter. Withdrawn. Petitioner counsel made a representative for the registry for withdrawal. Same accepted. If expressed as withdrawn. Item 2, G. Sudha. Pass over.
May your lordship, please. I'm here, your lordship.
Yes, madam.
Last time I have argued about this, your lordship. My learned friend wants to argue and give some citations, actually. Your lordship asked me for a write-up. My eyes are not got affected with allergy, your lordship. Your lordship.
Okay. Post after 1 week or 2 weeks?
2 weeks, Your Lordship. And let me give you the case law which is relying on it. That much is sufficient for me.
Okay, post after 2 weeks, yes.
Thank you.
Huh? Pass over, huh? Okay, pass over. Sir, this matter becomes infectious, I think.
But my only submission is
Uh,
the circular was under challenge and also sought consequential relief. With regard to
who is appearing other side? Sri Harsha Reddy. Yesterday he said
with regard to circular,
circular withdrawn. Yes, yes, yeah.
they say circular
Circular itself withdrawn.
withdrawn. But by virtue of the interim order, the petition was sent for medical examination and he was found unfit.
No, your question also challenged on 17, no? Circular 17.
17/10/2011.
Yeah, same was they themselves they withdrawn. What remains in this?
But by virtue of interim order, he was sent for medical examination.
Maybe after that, the subsequent actions, total circular was withdrawn.
But they have not taken any consequential action pursuant to medical examination. That is only by this thing.
Where is he, Harsha Reddy? Just you have to recollect while he was in stand.
Also, what I discussed with him, I told the same thing.
What he said?
He said,
If assuming also say suppose you are challenging on circular,
yes,
so you got the interim direction of the court by challenging the circular. So basing on the circular, they send for examination. So that circular itself is withdrawn. So automatically case is not there in favor of you also. You are eligible for that, I think, according to
my only submission is valid. My constitutional page consequently direct the respondents to refer the petitioner to the fourth respondent medical board and declare is unfit for the service of the respondent as per the Mines Act 1952. Mines Act says if it is declared as unfit, they have to provide dependent employment. That is
the withdrawal circular, while withdrawing the circular, what they said finally, you have that circular. Court of sir, that
is the only submission.
correct, you are right. I know once you see this again. One order is there, Navinda, same interim order, basing on the interim order, they said for medical examination.
Yes.
So if you are fit, they will take. If you are not fit, they won't take. That's all. So in that order, your case will go.
True, man. He was also sent for medical examination.
Oh, yeah, that's what. In this side, second page,
Yes.
they sent for medical examination, but subsequently writs are closed. So your cause is survived. If you are qualifying the medical examination,
Yes, he qualified.
they will take, or otherwise nothing.
That is only small direction. He was declared as unfit in the medical examination.
But we don't know whether you are unfit or not.
I've got the copy. I'll submit that copy also.
What you will do now? We'll pass it to the fairway today itself. Ask him to attend this, whatever it is.
He's there.
ఏంటి సార్ సర్క్యులర్ విత్డ్రా చేసుకున్నారు కదా you have the interim order, medical examinations happen, conducted. So what remains? If he qualifies, he'll join the job. If not qualifies, same thing as she is telling. What is the result of the medical examination?
That I have to find.
No, that's what.
My instructions are not, he was declared as unfit. Once he is declared as unfit, but they have to provide dependent employment as per the max.
I get proceedings.
That is the one.
No, yesterday your senior said that put this circular itself withdrawn by the department.
Yes, ma'am.
Basing on that circular only, the interim order was granted. And petitioner sent for medical examination. whether in the medical examination cleared or not, whether he fit or not, we don't know. If fit, he will continue. Otherwise, what is the subsequent action of the department? You have to provide alternative employment to the family member, dependent employment. So that is the deemed action. Nah? So why should we wait for this? No, I'll direct them. Circular itself withdrawn. Number one. Number two, of the observation of this court, basing on the interim order, petition is sent for examination, medical examination. If he qualifies the examination, he will continue. Otherwise, he proved unfit, the dependent employment has to provide to the family. Hence, the petition is disposed of. What do you say?
Tomorrow, my lord, yes, sir.
Okay, post tomorrow.
Just for clarification.
Okay, order the court of sir. This court. Tomorrow. No issue. For orders tomorrow. But both of you finally tomorrow morning close the case. Either this side or that side.
That is the only issue.
Yeah, you're right. Your point also right. Pass over. Other side, GP services 2. You are representing services 2. Yes, what is ready? Okay, next week. Next 2 weeks. Yes. Post after 2 weeks.
May I please meet?
Yes, sir. Other side, GP services 2. Ready?
It is a covered matter, Lordship. May I make my submissions?
No. If you say covered, if I accept it, they have to accept that it is covered.
Last occasions, Mukram sir attended the court and
Which order is covered?
is may I go through one?
You have that copy with you, Mr. Counsel? I'll pass it over, go and confirm from your seniors. Covered matter or not. Huh? Pass over. And you give it a copy to him also.
Sir, item 9. Another bench.
No. Item 9 and 10.
Yes, Miller.
The MACM, now we don't have that roster. It will go to appropriate bench. I released that 2 matters.
2019.
No, the MACM.
Yes, 2018 and 19, Lord.
19.
Sir, 19.
No, 9 and 10. 2011 MACMS. You are representing that.
Roster Miller 2019. The writ petition.
It is not.
No, sir.
Petition రాదు.
Which case you are discussing?
Sorry, Miller. Sorry, Miller. Apologies.
My lord, this matter pertains to termination services. Counter is required. My lord, may I request for me?
Where the employees are,
To one employee, my lord. Though that is a different case.
post after 2 weeks.
My lordship, my
Admit అయ్యలేదా? Admit అయిందా కాలేదా? Rule is post after 4 weeks.
yes, ma'am. That is a different case. 55.
May I please, Miller? The action of the respondent number 1, Miller, issue the impugned proceedings against the petitioner, Miller.
For the respondent, Your Lordships.
Hmm.
Kindly have it on 14, Your Lordships.
14th. What is the?
Chips, GP is on leave, Lord. GP sir, he has to appear in this matter. He requested for 14 days.
Sorry, Miller. Actually, Miller, the petitioner, Miller, unemployed, Miller. Already we have completed the 8-month training also, my lord. The discharge from duties, the police constable, my lord. This is main contention, my lord. This is not having power and authority, the first respondent. The second respondent is having the power and authority, my lord. But several times taken adjournments, my lord.
Now he's on leave, so we'll take up next week.
Accepted. The finally, my lord.
Will admit rule AC post after 4 weeks.
Sorry, my lord. This appointment, my lord, this unemployed. The
Lordship,
both petitioner also, my lord. At least
in fact, this was argued before another bench last time also, Lordships.
the
Didn't he
several bench, my lord,
take
before the bench, my lord.
argument simply, Lordships, as per his contentions?
Earlier bench also, my lord, both sides argue the matter, my lord. After, my lord, the roster was changed, my lord. Several times taken adjournment.
Post after 1 week,
Deeply obvious.
Like,
both the matters.
Lordship was pleased to grant interim order, my lord, to send the petitioner training, lord.
Already they informed you, they took time.
One submission, my lord.
What one submission? Nothing.
On 8th of, my lord, on
No,
8th,
nothing.
one
They
submission.
informed you. They said you
We
are
have not
accepted for
accepted. We
the.
have not accepted. Even was training, heroes training, ఎట్లా accept చేశారు చెప్పు?
That I don't know.
So today is a training. Today,
Don't play games with court. Mr.
not just no, my lord.
I once, twice I asked him. We are arguing at any type of any argument you are doing.
No, my lord, this honorable.
Why are you playing with court? One way you are accepting, you are fighting in the court. Second say you are accepting the contention request of the respondent counsel, taking time. What is this?
No, my lord, this is from
Nothing.
Lordship, day before day, my lord,
I asked him. You want to ask him? That's all right. I am not in a position to give any answer to you. I asked twice, and your sir give permission granted to take adjournment. I have given time. That's all. Post after 2 weeks, all the 3 matters.
Lordship, on submission, Lordship, on submission.
No submission. Still next matter.
Today, from today onwards, the training is going on. From today onwards, training is going on.
Sorry, don't hesitate the court.
It is tomorrow, my lord. I will argue tomorrow, my lord. Can you take it up tomorrow, my lord?
17.
But tomorrow, my lord, from tomorrow, the matter with the infectious, my lord.
Sai Reddy. Yes. 17 wrong posting, huh?
Not filing the case. Adjourned for 2 weeks.
18?
The counter is filed and
11th is training started, my lord.
Ram Gopal Ramarao. M. Ramarao. Where is he?
Lordships, matters also may be taken up on 14.
Okay, next week.
14.
14, you want 14? Okay, 14th. Post on 14th.
Simple matter.
ఇప్పటికీ
Milord, kindly pass over Milord.
Madam?
Pass over Milord.
Passover. ఏమైంది పాస్ఓవర్ అని పెట్టండి.
Instead of 19 password, Lordship tomorrow.
What is
Pass over Milord. Senior is.
okay tomorrow? PV Krishnaya 19.
Lordship, can you take up next week, Milord? This is also police recruitment.
18 tomorrow, 20 PV Krishnaya
Next week.
next week. Next week.
Deeply obvious.
Maybe take number Monday, Tuesday, Miladi last.
The post after 1 week.
Oh, bless.
Milord, item number 22 to 29 are similar cases, Milord. final year. Already this court was
Matters are admitted or not even admitted?
admitted.
Okay, we'll admit post after 4 weeks, finally.
No, my lord, already they have filed
Sir, these are
2 weeks, my lord. Granted 2 weeks, my lord.
Yes, I am granting only 4 weeks. You are asking 2 weeks, so rule is.
No, my lord, they are very senior citizens.
So 4
My
weeks.
lord, short period, short time, my lord.
Eప్పుడు వస్తుంది date చూడండి. You attend on 7/12, your case will be closed on that day. Post after this 4 weeks, rule is. Yes.
Obliged.
Up to 29, sir.
29. My lord, one submission, my lord. Connected matter 11/6/79. 2020 was not posted, my lord.
Okay, if it
Yes.
will check the fate of this case, then it will go on that way only in that matter.
No, it is also a similar case, my lord.
Item, which year?
2020, my lord.
Post along with number
Along with 11/6/79 of 2020. Obliged.
Similar matters, total subject matters one and the same.
11/6/79.
Subject matter is one and the same, sir.
One and the same, my lord.
In short,
Same.
what is the matter?
Huh?
In short, tell me what is the matter?
Wardens already you heard this court was disposed, my lord, earlier.
According to covered matter, huh?
Covered matter, my lord. Covered matter already.
Okay.
Several judgments were
Okay.
delivered this honorable court, my lord.
Okay, we'll see on 7th.
My lord, I am representing N. Indusan Reddy, my lord, is counsel for the petitioner. Here, my lord, this is a case of compassionate appointment, my lord. The employee, my lord, my lord, the employee Sambaya died in harness on 26/5/2017, my lord. While he was in service, my lord. He was a leading fireman. The family doesn't have any male children, madam. He has got only 3 married daughters.
You made any application?
Yes,
What happened to that application?
that is rejected. Rejected
What
is
is the rejection?
page 12 and 13, my lord.
12 and 13. Page 13, you read, sir, last to button, 3 paras.
You have informed that Srimati Gullapalli Anisha, daughter of so-and-so, is been living with her husband, Gullapalli Venu, so-and-so Kumarasamy, and married. Has neither been the conditions put there, neither she was deserted by her husband, or disappeared, or died. These are the extreme conditions put here. On this basis, this is rejected. And while this was in pending, my lord, they have also represented the second representative collector. Collector recommended their case, citing the GO number 370, my lord.
No, sir. You have informed that Srimati Gollapalli Anisha, daughter of late Nagapuri Sambaya, has been living with her husband, Sri Gollapalli Venu, son of Sri G. Kumar Swami, ever since the date of her marriage. Srimati G. Anisha has neither been deserted by her husband, Sri G. Venu, nor her husband disappeared for years together or died. It is clearly shows that she is not a dependent to the deceased employee.
Yes, that is their case, my lord. But the GO number 350, my lord,
Where is that 350 filed by you or not?
filed by them also. Page 19 to 20, my lord.
Huh?
Page 19 20. Para 2, my lord.
1920.
Yes, para 2. 19. Para 2. It has been ordered that where the deceased employee doesn't have any male child.
Where are you reading?
Page 19, my lord.
Page 19, order GOMS number 350.
Yes, ma'am. Para 2. it has been ordered that where the deceased employee doesn't have any male child, leaves behind him her married daughter and a married minor daughter, the choice of selecting one of the them for appointment under the social security scheme shall be left to the spouse of the daughter. Here, the mother, along with other two married daughters, give NOC to the second daughter. She is married daughter. So now, as per this, she is entitled for compensation payment. And moreover, my lord, they have filed the counter also.
Making representation, quote this GO in the representation.
Yes, madam. This is at page 19. Yes. We have submitted
This GOMS number. What, madam?
Yes.
She say?
Lordships, in the counter, Lordships, we have clearly.
Well, not
stated
counter,
the
GO is GO number. Tell.
Lordships, we have clearly stated the reasons why her application is not considered, your lordship. In counter page number 2, your lordship.
Page number 2.
Page number 2 of the counter, running page number 61 in us. Paragraph number 3, lordships. It is respectfully submitted that request of so-and-so was rejected for following reasons. She did not submit the documentary evidence that Srimati Anisha is dependent on parents in spite of her marriage, relaxing the orders issued in government memo number so-and-so dated 23/2004 and other orders focusing on dependent. Srimati Anisha is not the only married daughter and not dependent to the deceased government employee as specified in so-and-so. In the last para of GO memo number.
Your GO also quoted, sir.
Yes, sir.
So the Golapal Anisha is not the only married daughter.
Yes.
Not dependent to the deceased government employee as specified in GOMS number 350. So you are consider your case in proper manner. Yes. Next.
No. My lord.
Once I'll come to you.
Yes.
Next. Madam.
Srimati Golapalli Anisha is not made known as dependent mandatorily as per government number so and so. The surname of Golapalli is not Nagarpur. Lordship, she has not produced any document supporting her contingency, Lordship, and that is why her case is rejected.
This was raised in the last occasion also, my lord. Their objection was whether she is unemployed, her husband is also unemployed. We have under IA number 1 of 2023, we have submitted additional material papers. IA 1 of 2023. We have submitted the registration papers up to Anisha and her husband also. And unemployment certificate also. This was the question raised in that. Because of this, they were holding it. So these two certificates are submitted. Now, wife and husband both are unemployed.
What is IA?
IA 1 of 2023 additional material papers. So we have submitted the newly listed documents and well, no employment certificates. Both are unemployed.
Here is not the question of unemployment. You are dependent or not.
Yes, ma'am.
That has to prove.
Yes, but they have filed the counter in the counter para 5. They have simply rejected, saying that under memo number 406 dated so and so, she is not entitled for compassionate payment. On this, my lord,
She did not submit certain documents, certificates as required in government memo dated 3/26, dated 22/5/1995.
that is what. For that, we have submitted
According to the
additional
326.
Yes, for that only we have
Where is
submitted.
memo 326? You are filed memo 326.
Yes, Lordship.
73.
Page number 73.
It has been noticed that the appointing authorities, instead of functioning, furnishing the information as required above, are sending proposals for consideration for compassionate appointment to the government without obtaining the following documents from the applicants: death certificate, regular certificate, educational qualification with date of birth proof certificate, no earning member declaration from the applicant seeking employment, No objection declaration from the other family members, financial status of family members. So these 6 certificates you have to produce.
Already produced, man. Kindly see.
Where are those?
Kindly see, my lord.
Where are those 6
Yes.
certificates?
Page 44, my lord.
Page 44.
Yes. But no NOC, my lord. That is NOC from other members. 44.
Okay, so I'll dispose of the case. As per the counter, madam, as per counter, petitioner saying that he submitted all the required documents as per memo 350. If it is so, consider the same and pass appropriate orders within a period of 8 weeks.
My lord, in addition to that, my lord, we have submitted all the papers required, educational, backwardness.
According to you, you submitted.
That's it.
One is death certificate you produced, huh?
Yes, my lord.
Where is the death certificate? Where is your application along with all the certificates? You made an application with along with all the certificates.
Yes, my lord. Death certificate is page 45, my lord.
45.
Yes, 45, page 45. Death certificate.
Then legal aid certificate?
Legal heirs, my lord. Family members are 46, my lord.
Then educational qualification with date of birth proof certificate.
Yes, ma'am. And 47 is the no employment certificate. I'm just
Educational qualification with the date of birth of proof certificate.
yes, education there is also
That
submitted.
is no earning member certificate. I am asking you educational
Yes,
qualification
yes,
with the date of birth proof certificate.
yes, my lord.
Well,
Yeah. My lord, page 50, my lord.
page
50. Date of birth is 24/12/1987. Below that BCA.
oh, this is a page 50 something.
50.
Educational qualification with the date of birth proof certificate. That means if you are completed 10th class,
Yes.
show me the 10th class.
Yes,
No,
no, but date of birth is at 50. That is 24/12/87 is the date of birth. Education certificate, my lord. I'm coming to that. My lord. Page 65, my lord.
page
65. No, 30, my lord. Page 30. Secondary school certificate, this is. And see, and then graduation as well. Next.
then no earning member declaration.
Yes, right. So,
No objection declaration from the other family members.
yes.
Where is that other family member?
That is page, my lord. 44, 44.
Initial status of the family members from the revenue divisional officer concerned verifies whether the family is very poor
Yes.
and deserving for the compassionate appointment under the scheme.
Yes, sir. Economic certificate is 48, my lord. Page number 48.
So that is the reason why, sir, I'll direct the responding authorities as per their memo.
We have submitted all the papers, and when they raised whether they are employed or not, that also under YA 1 of 2020 we submitted there saying that they are both unemployed, and if there nothing remains, that there cannot be any objection from the respondents.
And their condition is that in that GO, hence the appointing authorities are requested to notify the vacancies in the prescribed format to government in general administration department and also to send the proposals with the above required documents to examine the cases. If no vacancies are available, a nil report may be sent to the matter.
Madam, Once, as per the no vacancies, my lords, I may be permitted to submit. Answer.
Yes, madam, what do you say?
Lorships,
As per your counter also, you are telling she is not submitted certificates.
yes, Lordship. Then another main contention is that she has to be a dependent, at page number 62 of my counter, Lordship, paragraph number 5. The requirements are there, Lordship. 62 running index, running page numbers. There should be no younger or elder unmarried dependents in the family, and the married daughter should be dependent.
Employment will be given to only one candidate.
And should be dependent on her
Once
father.
a marriage is performed, a daughter she is not dependent on her father.
Even if
Then
she
another
apply or her.
No, that is given number 370 clearly stated that even married daughters are eligible for employment.
350.
350. I know, my lord, one submission. And they have filed the counter saying that para 5, they have mentioned memo number 406 dated so and so. One submission. So they clearly mentioned in the counter saying that he is not employed as per memo. This memo is rejected by the High Court by appeal and in writ petitions filed by the petitioners. That is, the 4 cases are also married daughters. Kindly see the citations, my lord, one by one. I have submitted writ petition number
Where?
submitted the citations, my lord.
Which page?
WP number 26946 of 21.
Which page I have to see, sir?
No, the citations have no place.
Give me this copy then.
Submitted, well, already submitted. Even given to others also.
Citations, Nainala, Honorable Justice Nainala Jayasuriya.
Yes, Jayasuriya, my lord. This is just para 4, my lord.
You have seen this judgment, madam?
I have given them copies. I have given them long. This running months, my lord. Yes, para 4, my lord. The petitioner father died in harness while working as a concern. Respondent so leaving behind him the petitioner, her mother, and 2 married sisters. Here also married sisters are. And next, my lord, kindly see page 2, internal page 2, my lord. However, the 4th respondent, instead of considering the petition application, rejected the proposals while memo number so this memo number 406 they have mentioned. This 406 is rejected by this court in all citations. 408 is rejected because they are all extreme conditions. A married daughter, they say, are considering the case, they say either her husband should have died or waited for long and not be seen for several years. That's extreme condition. That's not accepted by this court. So all this citation that memo is rejected. Now, same, my lord, page 4, para 8, my lord, in the middle, the crucial aspect was not considered in the prospective by the respondents. I am simply referring to memo dated, that is memo 406 dated 23. The case of the petitioner was rejected on the premise that is a married daughter and living with her husband, and such is not the dependent, the deceased father. I further, my lord, page 6, same like the page 6. If the married status of son doesn't make any difference in law to his entitlement for seeking appointment on compassionate ground, the marital status of a daughter should make no difference, as the married daughter doesn't cease to be the part of the employee, and the law cannot make an assumption that the married sons alone continue this. And finally, my para 7, the order is there. In view of the above factual legal position, the writ petition is allowed. So, and hereby set the input order set aside. The respondents are directed to consider the case of a petitioner for compassionate appointment in a suitable post. This is one way. Next citation, my lord, a DV case. Division bench, my lord. Writ petition number 41391 of 17, my lord. Para 2, my lord. The father of the petitioner, while working armed residence, expired on so and so. Here also there are 3 married daughters. We cannot say that married daughters are more of now. Can you see page 3, page 3, my lord? In this connection, I am informed that the candidate Srimati Sashikala, married daughter of the Prakash Babu so found not eligible appointment as compensation ground in terms of the government crucial right number 406. 406 they mentioned. This is rejected. So, being aggrieved, the petition challenged before this OAI also dismissed. And on this OAI dismissal, they filed here challenge the OAI. And this court, my lord, was 5. Page 5, my lord, last para. Even if the applicant is residing in a separate house, that itself doesn't is not ground to reject the claim of the appointment. So far as the income of the appointment is concerned, it is proved that she is not having any independent income. So she is also taking care of the mother. And so no valid reasons are recorded in this case. And finally, madam, last para 8. But it's para 8. We are of the considered view that the case of the petitioner herein is one better footing than so. And therefore, the petition is entitled to be appointed in a suitable post on compassionate ground. The proceedings of the second respondent so are set aside. Consequently, the order of the tribunal is also set aside. So here the High Court not only set aside the respondent's orders, but also when the tribunal case was also rejected. Now another citation is 3017, my lord.
Citation
3017 of 2020.
Only 2 are here, sir. Only 2 are here.
No, submitted 4 mail. Chale. 3017 of 2020.
3017.
Yes, madam. Para 2, my lord. The case of the petition is that Sri Venkateshwara died in harness on so day. He left behind his wife and daughter, who is the petitioner herein. And in the same last lines, my lord, the claim of the petitioner on the ground that the petitioner was a married daughter who will not be eligible for compensation appointment on account of memo number 406. This is they have mentioned. So and on this matter, the council here said clearly this is rejected by the 2 courts of the High Court. And final matter, page 2, para 4. In both the judgments, memo number 406, this is what the contention is counter matter. That was the main contention. So dated 23 was considered, and it was held that the married daughters who may be residents of the separate house would also be entitled for compensation appointment. 5. In this circumstances, the present petition is allowed, and the proceedings endorsement so in respect of the set aside. Further direction to the respondents to consider and appoint the petitioner in a suitable post in accordance with law in within 3 months.
Yes, madam. What do you say? All these you have few only.
Yes, Lord.
And finally, one more citation, my lord, 16242.
It is also filed with us.
Same, my lord. All married daughters.
It's filed with us.
Yes, ma'am, all that.
Madam, once you go through it, all these things, why? Because all the judges citations are against you and 406 also referred in all the cases. Even though married daughter also can eligible for a compassionate appointment ground.
Lordships, I also have some certain side judgments, Lordships, wherein it is held that married daughters who are not dependent are not eligible, Lordships. I'll produce that also.
Madam, that was their contention, only that.
No, they want to see some other judgment which is against.
Yes, sir. Let them see, madam. No, no.
Open.
Yes. No, here is one bench order.
It is not there in my bundle. Court bundle is not there. Another citation. Only 3 citations we have.
1 minute, 1 minute. 1/6 court. Well, one minute. One minute.
Going to court of the level bundle leda.
That maybe, my lord, that I'll just bring it to consideration. Well, in that para, page 53, my lord, kindly see page 53.
Page
53, 52 to 57.
Yes, one judgment is there.
Yes, my lord.
Yeah, AV says that.
16242, sir. The father of the respondents, see, Ramchandra Raju worked as head constable, Amberpet. He died while in service, so and so did. And next, my lord, next
Leaving
page.
behind his widow and 3 married daughters.
Yes, ma'am. And next page, my lord, 53. The government GO number so and so, which was later clarified, extension the benefit to the married daughters. GO number 350 is also there. And memos are all there. Memo number 11641 or so and so date. Memo number 406, their contention. But this said application is rejected by 3 lines order by the Commissioner of Police, Hyderabad, so and so date. The respondent is not eligible. On challenging the memo, the respondent application approached and filed. Now considering the last para in the middle para.
It is fair case. So fair case, you have to appoint him. Or
Lordships may kindly post it next week, Lordships. Lordships may kindly post it next week, Lordships. I'll also produce it.
yes, whatever you said and show me, on that day I will allow the case.
One subject. My lord, earlier I have argued the case twice. They have filed the counter line, but they have argued the case. Only they are taking time to postpone. That for instructions, one time, 2 times, my lord.
When the matter is taken up today, GP for education ready? Who is appearing for this? 31.
Is a covered matter, my lord. The petitioner retired from service on attaining the age of superannuation in the year 2017. After retirement, they have issued the recovery proceedings. On 11/7/2017. After retirement, they have issued the recovery proceedings. Once retired, my lord, the respondents are not allowed not proposed to recover the amount as per the judgment of the Rafik machine. I am permitted to pass on manner wherein certain guidelines were framed from where the recovery has to be effected and from where the recovery has to not be effected. I am permitted to pass on.
Oh, yes. ఇది రఫీక్ మసే కదా? This is new one, huh?
Yes. But your last make any parents.
Yours is a fourth class employee?
No, my lord. Insofar as fourth and third and fourth class, they are not making. Your last make any parents.
No, Rafik Mess, I think fourth class employees are eligible to that extent.
It is also applicable to the persons who retired within 1 year. It is not the case that.
Show me that. Where is it?
Last but one page, my lord. Last but one page. There are 12.
There are 12.
It is not responsible to postulate all situation of hardship which would warn employees on the issue of recovery.
One second, sir. It's not possible.
Para 12, Maharaj. It is not possible to postulate all situation of hardship which would warn employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement. Be that as it may, based on the decision referred to herein above, we may, as a ready reference, summarize the following few situations where recoveries by the employees would be impermissible in law. First class. Recovery from employees belonging to class 3 and class 4 services, group C and group D. From class 3 and class 4, it is impermissible. And second is applicable to me. Recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. But now I retired from service on 36/2017. Recovery orders were issued on 11/7/2017. So after even before 1 year of retirement,
So when you are retired from service?
On 36/2017.
36? When the recovery procedure is issued?
Issued on 11/7/2017.
11/7/2017. Within 1 year, na?
Even
within 1 year it is. Next month you retired June, I issued 7th month, July.
Recovery from retired employees or employees who are due to retire within 1 year. But even if I am retiring within 1 year, they are not entitled to recover. Okay. If I am retiring in 2000.
Where is the other side? Who is the other side?
And apart from that, para 3 also, my lord. Recovery from para 3, recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. In my case, the matter pertains to prior to 5 years of recovery. So both clauses are applicable to me.
2 and 3 is applicable for you.
Yes, madam.
Where is he? Well, put it for orders next week.
Tomorrow.
Tomorrow
for order 6 weeks. Because the benches will be changing regular intervals, madam.
Yours is a fair case. There is no doubt with regard to your case. Benches also changed. Okay. Next week for orders.
Right.
Pass or not even admitted these two matters. Counters are filed. You don't have the information. Admit any explanation? Okay, rule is post after 4 weeks. Yes. Admit post after 4 weeks.
Appearing for petitioners, my lord. IA 1 of 2022 filed from both cases. For my lord, the arrears of the PRC amount is not paid to the petitioners. For that reason, filed these two petitions, my lord. My lord, after filing these petitions, they have stopped the PRC amount, my lord. After filing this IA 1 of 2022, they are sanctioned the PRC, paid the amount, but arrears are not paid, my lord. From the last 3 occasions, government has requested the time for filing order in this petition. But
Who is that side?
No, I am for the university, my lord, Ambedkar Open.
You are paying now, and your arrears are not paid. Why?
My lord, regularization matter pertaining to regularization. The government has to take decision with regard to that, my
You
lord.
are paying for government.
it is not regulation matter, my lord. The prohibition is declared in the year 2001. From the last 30 years, they are employees of the university.
My lord, we recommended to the government, my lord. Government has to take decision on it. My lord. We have filed counter.
That is in the main petition, my lord. In IA, it may be decided. From the last 2 years, we are not received the arrears.
PRC amount and other benefits to the petitioner pending in the petition. Where the benefits? What is there? What is
My
wrong?
lord, government has to
No.
say, my lord.
PRC benefit you have to pay, na? Government what?
The government has to release, my lord. Amount should be released by the government. We have filed counter.
We are received from the 2022. From 2022, we are not received arrears. That's amount we are asking. After filing this petition, they are sanctioned from 2022 onwards, they are sanctioned to PRC amount, which is allowed by the government. All employees are received that amount, my lord. Only to these 2 petitions are not received.
No.
It will be decided by
you want to PRC?
Yes, my lord. PRC amount. They are already sanctioned. We are received now from 2022 onwards.
Then from
2022, we are not received. For that 2 years, that arrears are pending before the R2 and R. They are liable. Government is not.
No, from 2022 onwards, you are
We are
getting. Which year you are not get?
From 2020
and 21.
2021, we are not received.
What is it?
No, I'll get instructions to that extent. 1 week.
Next week. Get instructions whether you pay.
IA 1 of 2022, I'll get it. Obliged.
Please, my lord. There is a very peculiar case, my lord. And
Who is appearing other side?
it involves.
Yes, ready?
Yes, yes. It was already argued on last occasion. I'll just make a very brief submission, my lord. It's a very simple point. A notification is issued.
For you, it's a simple point, Mr. Rahul, but other side.
Yes, yes. No, my lord, they are also aware. Once your lordship would hear this, absolutely they are making a very big case out of nothing. Once your lordship would see this, it's such a simple conscious matter, my lord. They have delayed and my lord literally avoided jobs for few people. It's a case of junior panchayat secretary notification. My lord, your lordships may kindly be taken to the notification.
Where now?
Yes, what has happened? Petitioners are all working. Few of them are working on outsourcing basis. They have to be made regular. That's all. Posts are there against which these people are also working, but outsourcing instead of regular.
Correct, but
posts are there, my lord, because they are working. Otherwise,
counter. Huh?
Yes, yes.
What they say in the counter?
The case is like this, my lord. Notification. They say that bilingual question paper will be given. English, Telugu, Hindi, whatever. So, person who is writing, my lord, he may choose the medium of instruction which he wants to write. So, if I chose in English medium, I can write in English. If I chose Telugu medium, questions will be and answers will be in Telugu also.
I think I had once.
No doubt. Now, what has happened? Petitioners before your lordships are all Telugu medium. 14 questions, my lord, they gave only in English.
Only English. Yeah.
Only English. And that 14 questions are comprehension, big paragraphs. They say this will be in English only. They never knew before it. If they attempt, they will lose 1 mark, my lord. And if they don't attempt, they lose quarter mark, 1 mark anyway. And if it is answer is wrong, they lose negative marking, 1/4 mark.
For that grievance, everybody have the grievance against the same question area.
Telugu. English people will not have English medium, they will write nicely English question paper.
Only these people are appeared for Telugu.
Yes, yes. Many will be there, Telugu.
That's question here.
Very few people.
60 people are came for.
They are probably very vigilant. They want job at any cost. They're all graduates, my lord, searching for jobs and
Any ruling is there? Ruling or citation if this type of mistakes are.
rulings are there, my lord. We have, I mean, they are there, my lord. There is rulings there, that's where the Honorable Supreme Court has been holding time and
Who is
again.
appearing for government, sir? What do you say? Or inform the GP or AGP or AG?
I'll inform that the additional agent. Pass over or tomorrow.
Counter what they say? Counter fight counter.
What they say, my lord, these questions, 14 questions pertain to English comprehension. Therefore, they will be in English only. They never stated in the syllabus.
Yes.
They never stated in the notification. Then even hall ticket, my lord, they say medium opted Telugu. When I have opted for Telugu medium and you say questions will be in Telugu, how can you put in?
Somebody this type of there are cases where they have to close one hearing only.
I do not want to venture much.
There is hard and fast thinking and judgments and rulings there. Multilingual paper, both language have to give. You are not given. You are eligible for that.
And please see the question at page 74. Just one glimpse, my lord. A Telugu medium guy, I mean, even for me to suddenly read Telugu will be very complicated. But for a Telugu person to read this much of English all of a sudden in a question which is not aware, page 74, he has to read this passage entirely in English and write answers in English. Is it possible, my lord? From there, 14 questions like that, my lord. Every page is in English. You have to read the passage, and out of the passage, they will ask questions. Questions will be in English, answers will be in English, passage is in English. Paragraph, reading an entire paragraph in English, my lord, suddenly for a Telugu medium will be very difficult. For instance,
notification, there is no such rule.
It says
some
bilingual.
Questions will be given only English.
No. In notification, it says bilingual.
Where is that notification?
Yes. The typical, my lord. Page 22, your lordship. And page 23, scheme of exam. Written examination, top, my lord. Written examination. The lordship got it.
Yes.
Just below that tabular note, question paper will be in Telugu, English, Urdu. Such a simple thing, my lord. They made it so
Urdu also is not there.
They made it so complicated. Urdu means there will be English and Urdu, separate paper. English Urdu will be there.
The English Urdu and English
Telugu. And they say there also we gave
it. Serious issue is not
small thing, my lord. They didn't. There was they just overlooked it. Absolutely, they should have allowed.
Nobody is asking anything, and
initially we had a scale.
Sir,
just on Monday, my lord, and we will discuss with you at the
Monday. I'll ask you only. You have to give answer for this.
And earlier
state case. Your notification says English, Telugu. You are giving only English questions.
Earlier Ben said, my lord, if you don't, you find out if you can accommodate these people anywhere in regular post. Otherwise, you tell me I will have to set aside the entire notification, was the observation of the earlier bench. And then, my lord, it came here. They still didn't get the instructions on.
For how many posts for notification? Notification for how many?
9,335 posts.
Notification cannot set aside.
No, my lord. That's how it was. I am only saying, my lord. That's how it was addressed. The intention was to get these fellows not to set aside.
Monday, post on Monday.
I'm obliged.
But I'll ask you only, sir. Tuesday, yes, Tuesday. Yes.
I'm grateful.
Ganesh. Admit any? All matters are admitted, not admitted.
Yeah.
Okay, rule is post after 4 weeks, all the 3 matters.
3 matters. 4 weeks. Admitted.
Rachana, Gadi Praveen Kumar, That's right.
Your lordships, I'm here, your lordships.
Yes, yes, madam.
Your
Who is
lordships,
appearing other side, Gadi Praveen Kumar.
Your lordships, it's a matter relating to forest employees, your lordships. These people have been on contract labor for a very long time, almost 25-30 years, your lordships.
Yes.
And they are the ones forest they do the manual and actual work of the forest department, your lordships, actually, and they are contract employees, and these are the people
Total
who,
166%, sir.
yes sir, they have been yes your lordships, they have been unceremoniously removed, your lordships. They have been unceremoniously removed in
Who has to
2019.
respond? Who has to respond?
Your lordships, the state government as well as the central government, your lordships, they have filed counters as well as replies also, your lordships.
Then what they say in the counter?
Your lordships, they state that your lordships, they state that your lordships, they state that they have they are contract employees and that they are rightfully removed, is what the state government says. The central government in support of them has stated that they have provided all funds under KAMPA, under the scheme where funds from the central government are given to the state government in order to accommodate not just human resources and capital, but also other aspects of the forest management, your lordships. The reason, this is the retrenched forest strike force, your lordships.
File any reply to this counter, madam?
Yes, yes, your lordship. The replies also have been filed. Your lordship would require to hear this finally itself, your lordship.
Respondent counsel is not there. Matter not even admitted. Will admit post the matter after 4 weeks, madam.
Your lordships may not admit it, but keep it in admission stage and complete the matter, your lordships.
Madam,
Because
since same in the same verbatim from 2019 onwards is coming on the same caption admission.
your lordships here.
We'll go forward one step forward, madam. We'll admit the matter.
Your lordships, may I?
On 7th finally, 7th December.
Yes, your lordships. May I make that submission? On 7th December, your lordships may post it at a specific time in the afternoon.
Rule post after 4 weeks. That is date given. What is the date, sir? 7/12 matter will be listed for final hearing.
For final hearing, your lordships. Final hearing. Yes.
Rule post after 4 weeks.
Your lordships, there are certain
petition also is
impleed
there,
petitioners also, your lordships. Your lordships may impleed those petitioners, your lordships.
What is the impleed petitions?
Impleed
Petitioners, 167, 168 petitioners.
167 and 168, your lordships. Impleed affidavit also has been filed. Your lordships may.
IA numbers.
I
IAs are not there, madam. IA 1 and 2019, IA 2 of 2000, stay petition and direction petition. You have an interim order, madam, in this.
Your lordships, no interim order, your lordships, but for finally, because it's a matter of removal of contractual employees, your lordships, it was going to be heard finally. But
IAs are not there, madam. IAs are not there in the bundle.
IA 1 is supposed to, IA 1 of 2023.
23.
I believe the impleeds have been allowed, your lordships, if I'm not mistaken.
Already impleed is allowed, madam.
If it's allowed, then
that is the reason in the call list that numbers are not showing.
Yes, your lordships.
Okay, rule post
I'm grateful.
for final hearing.
I believe, you know, item 41 is also similar item, right? It's connected.
Item?
41 is also connected.
40 also same.
40 and 41 are connected.
Okay, 41, yes.
Oblige, your lordships. On 7th December, finally,
Yes,
your lordships.
final hearing, finally, on that day we'll close the case.
Yes, your lordships. I'm grateful.
Sure.
What is the matter about, sir? Who is appealing from other side? Where is the tribunal order? One second. Page? In view of the above, the OA is disposed of in terms of the orders issued OA 7647 up to 2013. And where is that 7647 batch art? This tribunal has decided in number of cases that the limitation prescribed in GOMS 98 irrigation department dated 15/4/1986 for submitting application within 1 year of the acquisition of lands, houses is not applicable in case where lands, houses were required prior to 1986. In view of the above facts and circumstances, the respondents are directed to consider the case of the application to any suitable post under GOMS 98 irrigation. So irrespective of the date of applications and irrespective of the limitation. What do you say? The order is irrespective of limitation. Yeah. Mr. Counsel, irrespective of limitation, you have to provide employment to them. No question of escape here. Pass over or tomorrow? No, they will get instructions. Okay, next week. Dear Ram Subbarao, JD for services, 1. Counter is filed. Will admit post the matter of 4 weeks. Declaration will admit. By December 7th, it will be over. Final hearing, finally. Once it is admitted, what is this, sir? Kindly appreciate. Don't repeat old arguments. We have plenty of honorable judges. Matters will come once again and again. Other matters can be admitted where there is not this. But here, the regulation is seeking, is not getting anything. At least kindly consider granting of entry or admitting to our objection. I am asking the extension of minimum time scale pending regularization. Who is of counter is filed? Counter is filed. Who is appearing, Mr. Counsel, government?
Services.
Services 1.
Finance. Finance department.
When do you want? He is not there. What to do?
And before vacation also matter will come up for that. Before you have a report, but twice they have taken time for arguing the matter.
No, the counter what they said. Counter what they said.
Pass over after lunch.
Pass over.
Okay. I am seeking regulation in terms of what every judgment. 10 years is already completed. But he was appointed on daily basis. As well part-time sweeper and waterman.
What they said in the counter?
They say it is not the judgment of the Honorable Supreme Court is not applicable. The extracted judgment
in this case, as relief was granted, the such judgment, the person who are appointed in regularly sanctioned posts. If your persons are not appointed in the regularly sanctioned post, the case is not applicable to you.
Then my case is, brother, I am not appointed in sanctioned post. No.
Yes, if it is not sanctioned post, if you are appointed temporary basis against the sanctioned post, then the case is applicable to your case.
Correct.
You are not appointed under sanction against the sanctioned post, this case is not applicable to you.
It needs to be taken by the government, not by the department. Once of regularization, the decision of regulation whether it is entitled.
How are you satisfied with this? That what you tell me? How you satisfied para number 7?
There is impugn order, page number 12 also can be before going to that.
Page number
12 of the metal papers.
We have to approach government, not by the regular to court. That is also fair, it says. Honorable Court, the grievance of the petition is directed towards the memo issued by the second respondent. The petitioner ought to have approached the government, who is the competent authority, ventilating his grievance against the impugned memo.
I request
You approach the government or not?
I requested the government to consider my case. I made submit application through proper channel. That is sent to the head of department. But instead of sending it to the government, he passed an order. The person kindly see reason given in page 12 of the metal papers. Instead of sending the application to the government for consideration, when the second respondent head of department straight away rejects it. Reason put forth is not that the document pair 2 of the impugned order. In the instant case, document kindly pair 2 of the order impugned. Page 12 of my metal paper.
Page 12.
Page 12 minute.
Yes.
Pair 2. In the director of state audit, when the order is possible, director of state audit. But in the instant case,
You are reading, sir.
page 12 of pair 2 of 5 metal paper, paper.
This is your metal paper, na? 12.
Pair 2. In the instant case, so office of the regional deputy director state audit zone 5 Warangal has been appointed as part-time super cum waterman in the office of the regional deputy director state audit zone 6 Warangal with effect from 1/2/1989 and has not completed a minimum period of 10 years as on 25/11/1993. The date on which Act 2 of 1994 came into force. The reason put forth is I have not completed 10 years as on 25/11/93. But that cannot be. But once my case itself is when I appointed in 1989, the Honorable Supreme Court said, as and when I completed 10 years of service, they have to have considered my case. That is the law of the settled by the Honorable Supreme Court. Instead of saying that, when they say as on 25/11/1993, because I have not completed 10 years of service, the claim is rejected.
Who will argue, sir, in your side?
Services one only.
Where is he?
Password.
Well, last may request that last may set aside this. Send the matter back to the government for consideration. That's all.
Okay, we'll pass over, we'll see.
Very good.
Right. Item 44. Ganesh. Admit and I. Okay, rule missing post after 4 weeks. Same.
Matter relating to non-payment of terminal benefits here.
Non-payment of terminal benefits. Counter file,
Counter filed your lordship. There, after filing this request, some of the terminal benefits are paid.
Remaining not filed, huh?
This leave encashment is still due, your lordship. Leave encashment is still due. And
what is this, sir?
my submission is.
How much time you want for payment of remaining things?
The 2018 February he retired. Now we are in 2023. Lordship, 5 years over, your Lordship. Leave encashment is not paid. Gratuity is paid less because they have not calculated total service. 2 years period of medical unfit where he is directed to be provided alternate employment with all service benefits, that was not counted. And 1 year service in the initially where he worked on contract daily wage basis, that is not counted. Total service is not counted because while at the time of retirement on medical grounds, your Lordship, he was paid some forcibly paid PF and gratuity.
Why
That
they are not paying? Under what ground they are not paying? Any
they are not paying simply without any
criminal cases are pending?
No, nothing. No employee is being paid full terminal benefits, your Lordship. Same reason, your Lordship. No employee is being paid total amount.
What is this harassment, sir? After all, small
5 years.
size.
Shramik, your Lordship, he is a Shramik.
Small, you harass IAS, IPS officer, not this small employees who are working for bread and butter.
Process counteracts only TBL only every matter. That is also we are acted to for giving the
Last occasion, your Lordship, matter came up before 22nd court and
it is submitted that the following benefits are paid to the petitioner.
Yes.
8 items are there.
Yes,
all 8 items paid, huh?
No, your Lordship.
One is TBL is due. TBL is due.
Not paid.
Why?
1, 2 items.
When do you want to pay? Tell me the date. I will agenda the matter for that day.
Monday holiday.
Okay, post on Tuesday. Get instructions.
Obliged.
Okay, rule is post after 4 weeks. $48, sir.
48. Is your Lordship.
GP for revenue, GP for services 1.
I argued this matter before your Lordship in the last occasion. Covered matter. For instruction of GP, it is adjoined, your Lordship, and it has not listed under caption of for orders, your Lordship. Readings over, your Lordship.
What is, sir? Passover. The Passover. Yes, sir. But this week is not there.
My lords, I am appearing for the respondents, my lord. Kindly pass over the matter, my lord.
Passover.
Yes, my lord.
What is it?
Passover, I have no objection.
Passover.
Obliged, my lord.
This is a matter of questioning the reversion order minutes. As well as IA 3, IA 1 of 23, I filed an additional metal papers. It may be allowed, my lordship.
Okay, IA 3 is allowed.
IA 1 of 23.
IA 1 of 23 is allowed. Next.
I'm ready. Last occasion also they took their time to argue the case, ma'am. In fact, I am ready to argue the case.
What is this, sir? Ready? Okay, next week.
Much obliged.
Coming up for count of the respondents, madam. Third employee.
Who is appearing?
Murali Krishna is for the.
Murali Krishna is the counselor.
Counsel for this now, Accountant General Officer, AG officer.
AG office. Count is filed as a not.
Count is not filed by the government, either by the government or.
Count, bundle have the counter.
Papers are not served on.
Serve the counter to him, will take up the matter post after 2 weeks. So viewers are also asked me, sir, and why? Because they filed counter in the court bundle. Ask them,
I'll take
they won't.
The case of compassionate appointment, your lordship.
Yes, sir.
Being appointed in 2007. Regularized matter, completely working. 2018, some third party might have given a complaint basing on which without any inquiry.
Counter is filed.
I obtained the interim order, you are continuing.
So nothing survives.
I am continuing in the service.
Yeah, you have the interim orders, you are continuing services.
Yes.
Okay, no further orders are required.
Yes.
Case may be closed. What is IA? Vacate petition file. Huh? Why? Why vacate petition? Who are you? What is the relation between you and petitioner? No, this is compassionate appointment.
Yes.
You are questioning compassionate appointment or your seniorities? Who are you? Who are you?
Complainant. Third party.
I stand next to means our father and successor worked as PRS in that. But so we have recommendations to the collector.
Collector has given any response to your representation?
Have made several representations.
Then you filed that separate writ petition. What is the why you continue in this case? No, sir. Objecting his appointment, you made a representative before the collectors. For that, you filed separate writ petition.
That too in the year of 2018. But whereas I am appointed in 2007.
Presentation from
No, when the compassionate appointment was taken place?
2007 itself.
When you are questioned?
They are present. We have given the
That's what. I'll close the case. If you want anything, you made a repent that you insist for the disposal of your representation, or you file impleading him, you file some other writ petition. Why should you continue in this case again?
Actually, me tomorrow.
What is the role of the third person when I am regularized and everything and that too after 11 years?
I'm not saying you are not affected or affected. I'm saying by way of your implead petition is not at all ordered till today. Not at all ordered. Number one. Number two, it's a matter of 2018. Appointment of 2007. Interim order is there. And the regularized services. Correct. Once the regulations of services, how you question number one. Number two, you made an application before the collector.
Complaint.
That complaint was not disposed of. So what will be the next course of action? We are pending this case. If you have any grievance against that complaint, you file a separate writ petition, making him party. Tomorrow.
May I please, your lordship?
On the other side, Rami Ramarao was seeking time all these cases.
Yes, my lord, but this is a matter, my lord, you have heard this matter 1 year back, my lordship. Already I have argued, it was coming up for their arguments. But every time, my lord, the petitioner is out of service since 2018, my lordship.
They filed counter. Huh?
They have filed the counter, my lordship.
What, sir? What they said in the counter? What, sir?
Next week, my lord, special GP is not, my lord, the leave. My lord.
No, how many days special GP will not available?
Next week, 14/11.
So the small issue in this, my lord, he was removed from the service stating that he was involved in a criminal case in which the FIR has been registered. Subsequently, a charge sheet was filed, my lord, wherein the petitioner name was not mentioned. It is not there. His name was not included in the charge sheet. By virtue of the deletion of his name in the charge sheet, he has to be reinstated. This is the small issue which has been involved in this case, my lord.
For that, to made a name representation, your name is not there in the charge sheet, so kindly consider your case.
I have to verify that, my lord.
You verify that why? Because
But my lord, because the
presentation.
one submission, my lord, by because the petition is pending as on today.
Correct.
I
We're searching for shortcuts. If any referendum is filed for you,
yes, my lord.
we'll ask them to consider the application, pass appropriate orders.
Next week, my lord.
Post next week. Yes, sir.
Please, Lord. I filed IA2 for receiving additional material paper, may also the representation dated 21/10/2023 as material paper in the petition.
IA2 zone, IA2 zone.
IA1 is for seeking a direction to consider the said representation.
Is it IA2? IA2 is not there, sir, in our bundle. It is there or not?
Yesterday it is numbered and
today it is numbered.
Yesterday it is numbered and
Today 1 week, sir.
it is printed in the call list, but it appears it is not present.
Okay, we'll put it, but day after tomorrow or next week? Next week. Next week. And ask them, put up the IA in the bundle. Put up, sir.
Case where my lord, petitioners are joined as MPHA female, my lord. Since 2003, my lord, these petitioners are working continuously. My lord. No, my lord. In other cases, my lord, the counter is fine.
So post after 2 weeks for counter.
That, my lord, that the lord may kindly say finally, my lord, because they have received fair-wise remarks, and that may be mentioned, my lord, because since 2018, my lord, in other matters they have filed, my lord, if there are.
Assume if I say finally, what will happen? They'll finalize the copy on that day.
It's not my endeavors, my lord. If the submission that they have received fair-wise remarks is stated in the, observed in the docket sheet, my lord, that may, by expectation, that may
They
give a
file,
thing.
don't worry.
As it pertains to the notional promotion with effect for there is an interim direction, your lordship, even though they are not implementing from the 2022 year.
Interim direction is there.
Interim direction is there, your
Who is
lordship.
appearing other side, sir? Additional Advocate General.
Promotion for the post of Deputy Commissioner, Endowments Department.
You have not filed any contempt, madam?
No, your lordship.
Why? Order of 2018.
22. 2018, yes, sir.
The respondents are directed to consider the case of the petitioner for promotion to the post of Deputy Commissioner.
21st December 2018.
Otherwise, they have not passed any order also. What, sir? There is interim direction on 21/12/2021. The respondents are directed to consider the case of the petitioner for promotion to the post of Deputy Commissioner Endowments, if he is otherwise eligible. You have to pass some other yes or no.
Standing council is there, not the Genco.
Name is there. Name is
Or Vinod Reddy.
name not printed, huh?
Not printed. A Deepthi printed.
You are paying for R. Vinod Reddy?
No, Lordship, I inform her, Lordship. Endowments, we are not, endowments department, we are not.
Endowment government transfer only. TS Genco. TS Genco.
It is
57.
but authorized Deputy Commissioner Endowments.
Endowments.
Wrongly printed.
Authorities appeal for sudden power.
Endowment.
Just appear.
Genco or no? Respondent.
Endowments.
Endowment.
Endowments, case is endowments. Respondent to endowments.
Endowment standing, J.R. Manohar is standing council.
You know phone number of J.R. Manohar Rao? Huh?
J.R. Manohar.
Those next week, direct the registry to print the name of J.R. Manohar Rao
Standing council.
in place of Deepthi. Standing council.
For standing council. Endowment. Endowment.
Deepthi for
Oblige.
58 and 59. Jacqueline साहब बोलिए.
Find the counters, meetings are completed. In fact, this matter was heard by your lordship. Lordship was sitting in the same law.
Anything survives, sir? Anything survives?
There's a appointment of junior lineman. Notification issued in 2018.
What is your stand, sir? They are not eligible, huh?
No, you're not saying that they are not eligible initially. Selected. But subsequent there are two names of selection process. One is by first is written examination. Once somebody qualified in that and come within zone of consideration, we'll issue call letters for poll claiming test. That is also a must. One of second list. They were subjected to poll claiming test. The another issue was this: all four power companies, if somebody is working as an outpost person, they are entitled for weightage of marks to a maximum 20 marks, 6 marks or 1 mark for each 6 months. Accordingly, my lord, some of the petitioners in first petition, they were also, my lord, they got marks as outpost person. Then after this process was over, before issuing appointment orders, a revised list was submitted by TSHC, one of the sister concern of the MPTC. In that, they said some 400 people, they were also written examination. They have written examination. Therefore, this list marks had been revised. Therefore, the petitioner before this honorable court, they were not appointed because they were because of the revision of list. They secured lesser marks. The other people secured higher marks in the written examination. So, contention of the petition, they have been.
Once already they have announced.
Yes, ma'am.
Their names were announced.
No, results were not announced. They are provisionally selected. There are two provisional selection lists, and the notification says that till the orders are issued, they are at provision stage. That all I'll list before you not.
Yes, sir.
Ask me that.
No, yes, sir.
My lord, the petition. My lord, may kindly take the WP number 21331 of 2009. My lord. 21331. Item number 59. My lord.
How many matters are there, sir?
There are 3 matters. My lord. Mine is item number 59. That is WP 21331.
59 and 60. Only 2 matters.
58, 59 and 60. All 3 are connected.
58 one,
Yes.
58, 59 and 60.
That's 2.
Yes.
My lord, the second respondent, that is the Northern Power Distribution Company Limited.
Who has to appear for other side? Gabriel is
I'm appearing on three.
Yes.
My lord, the electricity department, my lord.
No, I'll ask one thing, Mr. Popule. Any ruling is there, in certain cases it should not be happened.
My lord, magistrate judgment. First one.
Magistrate judgment.
And in fact, notification itself is very clear and categorical that the petitioners who are called for poll claiming test in the ratio of 1:1 should be given a point.
Okay.
That's why. My lord, and the same is evident from the notification itself.
Okay. Show me the notification, para 14.
Can you see page 14, my lord? This is the notification issued by the Northern Power Distribution Company Limited to recruit and the post advertised is my lord junior lineman. Number of vacancies are 2,553. And my lord, page 15, the education qualifications. Junior lineman, the education, there is no dispute about. And then my lord, kindly see just that paragraph, double statement, my lord. Small Roman number 2. The qualified candidates will be called for poll climbing test in the ratio of 1:1. Duly following the rule of reservation and spirit of presidential order. Then note, the candidates who qualify in the poll climbing test will only be eligible for appointment to the post of JLM. So that is junior lineman.
So your petitioners all qualified for it?
All qualified, there is no doubt about it. All are qualified educationally and all are qualified in the examination and for poll climbing test also. That is one post, one time. It is not a case of 1:3, 1:9. If one post is there, one candidate will be called for.
Yes.
If that person succeeds in the poll climbing test, he should begin appointment. Okay. That is the terms of the description of the notification. My lords, may kindly see page 16, my lords. Page 16, bottom, third. That is paragraph para 8, para 3, how to apply. My lords, the TSNPDCL, note, my lords, the TSNP note 1, TSNPDC is not responsible for any discrepancy in the biodata particulars while submitting the application form through online. The applicants are therefore advised to strictly follow the instructions of the user guide on their own interest before submitting the application. Then, 2, the particulars furnished by the applicant in the application form will be taken as final, and the data entry is processed based on these particulars only by the computer. Candidates should therefore be very careful in uploading or submitting the application form in online. Then 3, incomplete, incorrect application form will be summarily rejected. The information, if any, furnished by the candidate subsequently in any form will not be entertained by the NPDCL. My lord, I will read once again, my lord. Incomplete, incorrect application form will be summarily rejected. The information, if any, furnished by the candidate subsequently in any form will not be entertained by TSNPDC under any circumstances. Applicants should be careful in filling up the application form and submission if any lapse submission. If any lapse is detected during this scrutiny, the candidate should be rejected even though it comes to the final stage of recruiting process or even at the last. So, my lord, the applicant should furnish the application or should fill up the application form and submit the same through online in strict compliance with the notification.
So their applications are not at all rejected, all are qualified.
And one more thing, my lord, they are not entertained. Any of the subsequent information will not be entertained from any of the part.
Then what don't they stop your recruitment?
Yes, my lord, I am talking. Then, my lord, page 18, my lords, para 7.
Page 18.
Page 18, my lord. The following documents should be produced by the candidate. The following should be produced by the candidate for verification at the time of poll claiming, that's our claiming, before finalization of the selection list. Then, my lords, page 10. Page 19, my lord. Important provisions governing the recruitment process. Vacancies. Item number 1, vacancies, my lord. Recruitment vacancies are not, there is no dispute, my lord. Recruitment. The recruitment will be processed as per this notification and also as per the rules and regulations. Yes, and PDCA. That is Northern Power Distribution Corporation. Then, my lord, page 22. Theme of the examination. The written test comprising theme of the examination, para 7. The written test comprising 80 marks, consisting 80 multiple choice questions, and each question carries 1 mark. The section A concerns, and the duration will be 2 hours. So the written test is only for 80 marks. And then, my lord, details of the written test, that is not so relevant, my lord, because there is no dispute about it. Then, para 23, page 23, my. Procedure for selection, para 8. Para 8, my lord, procedure for selection, page 23. Evaluation shall be done as follows. Total marks 100, written test marks 80, then weightage marks for in-service outsourced workers engaged on contract basis working as on the date of this notification and who qualify in the written test, 20 marks as indicated in item C. So weightage refers to 20. So written test is for total marks is for 100, written test is for 80, and 20 is for weightage marks. Then there is a minimum qualifying mark in the written test. Minimum qualifying marks in the written test as per rules. OC 40%, BC 34%, SC 30%. Then 3 my lords. All the eligible candidates will be called for poll climbing test in the ratio of 1:1, duly following rule of reservation and spirit of presidential order. The candidates who qualify in the poll climbing will only be eligible for appointment to the post of JA. That is no. So the people, the applicants who qualified in the written test only will be called for poll climbing test in the ratio of 1:1. If I succeed in the poll claiming test, my lords, you have to give an appointment. That is the prescription in black and white, my lords, of the notification. There will be no interview. That page 24, my lords. D. There will be no interview. D, my lords. D. Then, my lords, G. Provisional selection shall be made at first instance, which shall be confirmed later. In the meanwhile, if any adverse information is received about the genuineness of document certificates produced, the provisional selection shall be cancelled without notice to the candidate, but such intimation of the election will be communicated.
So it is also there officially. If any discrepancies or any complaints.
If any complaint or adverse information,
that
these use of the service
selection will not be started.
Genuine of the records.
The genuineness of the certificate produced by the candidate. If any such adverse information is received by the corporation, my candidature can be rejected. While so such is the state of affairs, my lords, they conducted the.
Everything is in our favor. Why they stalled?
Yes, my lords, because my lords, this is the information for educational services. I am bringing your lordship kind notice. Subsequently, my lords, they conducted the written test, and all the candidates qualified in the written. And subsequently, my lords, they
called for poll claiming.
Call for poll claiming. Yes, then poll claiming test is. My lords, may kindly see. Page 59, my lords. Page 59. This is a sample copy, my lord. This is issued on 9/1/2019. As per the result of the written test, written examination was conducted on 8/4/18. And as per the result of the written examination conducted on 8/4/18, against notification dated 16/2/18 for the direct recruitment to the post of junior lineman, you are hereby called for poll climbing test on the verification of original certificates, documents on 19/1/2019 at the office of so-and-so TSHC Telangana. So they sent a proceedings, my issued and sent a proceeding letter, my lords, calling me for poll claiming test on the ground that I succeeded in this test. And accordingly, my lords, I attended the poll claiming at page 60. and has received following original certificates and documents from so and so on his provisional selection. Since I succeeded in the poll claiming test, because all the candidates are taught for 1:1 ratio, I succeeded in the poll claiming test. They received all the original certificates from me. And by declaring that I was provisionally selected for junior lineman in
It's provisional selection.
Yes,
The
ma'am.
junior lineman.
Yes. So they said they agreed that my selection is completed. My provisional, they are declared that I am provisionally selected. And they have received all the original certificates from me. Till date, the certificates are retained by them. And subsequently, by that, all the petitioners were issued this type of acknowledgements manner by declaring that they are also provisionally selected. But they are not given.
They are not?
They are not given a point.
Why reason is there? Any documentary reason is there?
Yes, they stated so in their count of votes manner. And then I filed this petition. And then they filed the counter of it.
Where is counter?
Yes.
Good. But it is not. 21331 of 2009. Counter filed by the respondent number 2.
Yes, ma'am. Respondent number 2. On 13/2/2020, there is one counter minus and additional affidavit dated 27/7/2021 and a memo dated 30/12/2020. There are 3 documents minus. I am permitted to read that counter dated 13/2/2020. In this minus, out of the 24 petitions, the respondent stated that only 3 petitioners, that is petition number 4, not qualified in poll claiming test. That page, internal page 6, internal page 6. And petition number 19, J. Ramulu, not interested. And petition number 24, not qualified in poll claiming. These 2 petitioners who could not qualify in the poll claiming test, according to them. But I am disputing this here. I have stated so in my reply.
You received the letter, huh? Acknowledgement.
No, there is no acknowledgement. Their counter they stated so. In fact, my lord.
No, according to you, this is wrong. So these 2 persons are provisionally selected according to you.
According to me, there are 2 persons provisionally selected. They have taken my original certificates. In fact, my lord, I could not petition number 4, 19, could not produce the caste certificate. They directed me to submit the same. And I submitted the same. Now in the counter of they said that 4th petitioner and 24th petitioner did not qualify. And my lords, at page 6, my lords, so far as count is in the present counter panel, the stand of the corporation that except these 2 petitioners, the remaining petitioners, 22 petitioners in poll claiming test. Those selected petition number 19 is not interested according to them. Then my lords, at page 6, why they did not give appointment orders? The reason is this, my lord, page 6. It is paragraph 6 of page 6. It is submitted that from the above mentioned facts, it is clear that either the petitioner did not secure the cutoff marks or paid the poll claiming test. So now they are saying that they did not secure the cutoff mark.
These 2 persons. Not all.
Either the petitioners did not secure the cutoff mark or failed in the poll claiming test.
That means all, huh?
No. They are referring only to 2
They submitted that from the above mentioned fact, it is clear that either petitioner did not secure the cutoff marks or failed in the poll claiming test. As such, there is no merit in the writ petition and so on.
Yes, ma'am.
No, the ambiguity is there. Para 6, it is for all or only 2 persons.
Paragraph 5,
The
page 5.
particular writ petition for how many petitions are there?
24 petitioners.
Page 5, I have given a tabular format.
Yes, it is there.
There is a cutoff mark. According to them, they did not get the cutoff mark. 22 petitioners and 2 petitioners could not succeed in the poll claiming. The cutoff mark is only stated so in the counter. That is not in the notification. According to the notification, no cutoff mark at all. Notification says that whoever comes for poll placement in the ratio of 1:1 will be given a point. They are eligible for a point. But now in the counter of they developed their case that there is a cutoff point. And petitioners could not secure the cutoff point. So this is directly in contravention of the Manjushri judgment of the Honorable Supreme.
What is that Manjushri judgment?
2008 judgment, my last. They should not change the rules of the games after the game has begun.
Sir. There is a relevant portion.
I'm sorry. Minus. Minus, I may permit to, yes, I underline for my sake, minus. I permit to read it into that.
Sure.
The paragraph numbers may not carry minus, that is reporting some other that will not. It is downloaded from the, okay, I'm sorry, madam. My lords, in paragraph 11, my lords, the declaration of law that, my lords, therefore, introduction of the requirement of minimum cutoff, minimum marks for interview after the entire selection process was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified in this view by several decisions of this court. It is sufficient to refer to them, to three of them, that is, P.K. Ramchandra Iyer, 1984 2 SEC 141, 1985 3 SEC 721, and 1987 4 SEC 6 parts. They extracted all those judgments from that relevant paragraph. And my lords, in Maharashtra State Road Corporation judgment, that is reporting 2001 10 SEC 51, this court observed that the rules of the game meaning thereby that the criteria for selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. In this case, the position is much more serious. Here, not only the rules of the game were changed, but they were changed after the game has been played, and the results of the game were being awaited. This is unacceptable and impermissible. And my lords, at paragraph 14, we have no doubt that the authority making rules regulating the selection can prescribe by rules. The minimum marks for both written test examiner interviews are prescribed minimum marks for written examination, but not for interview. Or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum cutoff marks as stated. But if the selection committee want to prescribe minimum marks for interview, you should do so before the commencement of the selection process. If the selection committee prescribed minimum marks only for the examination before the commencement of selection process, it cannot either during the selection process or after the selection process have an additional requirement that the candidate should also secure minimum marks in the interview. So they should not add any minimum marks in the interview. What we have found is to be illegal is changing the criteria after completion of the selection process when the entire selection process proceeded on the basis that there will be no minimum marks for the interview. So my lord, they fixed the cutoff mark minimum quality of the examination. I secured minimum quality mark. They can't be for whole place in the range of 1:1. I successfully completed the same. They declared that I am provisionally selected, and they have taken all the original certificates from me. And we are waiting for the appointment letter. Along with all the other 2,000 candidates, they said that no, you could not secure the minimum cutoff mark in the they stated so in the counter.
All the 25.
All the 22. Then I find then subsequently the son that is good. And some
Imprimatur is there in this?
no
Imprimatur.
no imprimatur. That means the set several times relations also had this case in the last litigation matter. And subsequently they filed additional counter. In the additional counter, they came out with another story. Earlier story is cut off mark that is contrary to the notification.
Yes.
It's also contrary to the settlement principles of declared by the Honorable Supreme. Additional count of it, additional period 27/7/2021. Additionally, is there?
27/7/21.
What is this, sir? State case? Not state case? Huh? How can it be?
Most starting was if they stated something not the office.
No.
Next part.
Okay. What they have wonders, I don't know. Oh, yes. Oh, yes.
Yes,
what is, yes, on the second ground?
Now
What is,
they developed the version.
second story.
I am not
Second story.
Yes, ma'am.
First story is cut off marks. Second story?
Second story is my lads. My lads, the written test was conducted on 8/4/2018. And my lads, the NPDC, apart from NPDC, there is TSHC also. That is one of the entities of the Health State Department of the State of Telangana. The candidates,
According to you, whatever they say 100 reasons, that should be in the notification linked. If there is no issue in the notification, they may say 1,000 reasons, that reason is not applicable, your candidature is required.
That is my
So appoint.
because my lads, they may say that they will take counter of it. That is it is my duty to bring you informative answers that what is their standard, what is my answer.
Yes.
That's fine. My lads, the TSH, apart from NPDC, which issued the notification, TSS petition also is there, and some of the petitioners and applicants are working in TSS petition also. So the outsourcing people are given weightage marks. They are the TSS petition sent one merit list minors, a list of 449 candidates. On 8/4/2018, written test was conducted. TSSPDCL, by its letter dated 8/6/2018, submitted a list of 449 candidates of in-service outsourced workers. My lords, at this juncture, I am permitted to once again read the relevant clause.
What is the second issue they discussed in this additional?
Yes, I am coming. Only 1 second, my lord. As per the notification, my lord, no merit list or no revised list should be submitted by any other entity. Only petitioners have to submit their certificate. Notification doesn't call for, did not call for any of the lists from the TSHC, NPDCL, TSHPDCL or transfer DIMCO. No. What the petitioners have to submit their certificates. If these certificates are genuine or otherwise, the TSHC, NPDCL has to take action. But no authority is entitled to submit any list. But my lords, in the initial case, the respondent stated that, my lords, after the written test conducted on 8/4/2018, TSHPDCL by its letter dated 8/6/2018, that is 2 months after the written test.
8/6/2018.
Submitted a list of 449 candidates of in-service outsourced workers working with them. Having considered this list, my lord, NPDCL prepared the selection merit list and called all the candidates as on that date for 4 kilometers, including your lordship's petitions. Petitioners in the instant case, my lord, for call for 4 kilometers at page 59, my lord, on 9/1/2019. In that notification, in that order, my lord, this was conducted 8/4/2018. TSHPDCL submitted a list of 449 candidates on 8/6/2018, and they called me for 4 kilometers on 9/1/2019. I successfully completed this year. And my lords, paragraph 7, my lords, at page 4 of the additional count of it. Two of the paragraphs which are relevant, not spelling or not. Page 4, para 7, sir. It is further submitted that the written examination held on 8/4/2018, wherein in-service outsourced workers working with TS Power Utilities, as of the date of notification, also appeared, and they are entitled for weightage marks depending upon their length of service in terms of the notification. After the results were declared on 25/5/2018, the power utilities such as TS Genco, TS Transport, TS SPDCL submitted list of in-service outsourced workers working with them and who appeared in the examination. The TSHPDCL by its letter dated 8/6/2018 submitted a list of 449 candidates of in-service outsourced workers working with them. Accordingly, a merit list was drawn by taking into consideration the marks secured by the candidates who appeared in the examination under 8/4/2018, including the in-service outsourced workers working with the power utility. Thereafter, call letters were issued for full-claiming test. And verification of certificates for full-claiming test and full-claiming test and verification conducted on 19/1/2019 and 2/22/2019. In this full-claiming test conducted on 19/1 and 22/2/2019, all the petitions appeared and they successfully completed the set. Since some of the so my lord, up to 2019, whoever completed the full-claiming should be given appointment in the first instance. That's for the notification. Since some of the candidates either failed in full-claiming test or did not appear, second merit list was prepared and call letters were issued to the candidates who came within the zone of consideration for second phase of full-claiming test, which was held between 19/6/2019 to 25/6/2019. Okay, there are enough number of vacancies. Some of the candidates could not. In fact, my lord, if people who could not come up for full-claiming on the fixed date fixed, they should not be given an opportunity. But the TSHC thought it fit to give an opportunity and conducted full-claiming tests on 19/6/19 to 25/6/2019. And the last phase was conducted 18/7/2009. So, by 18/7/2019, all the 3 phases of full-claiming tests was completed. The entire action process was completed. All the petitions successfully completed full-claiming test. And as per the notification, description that is full-claiming test can the full-claiming test once the candidates will call for declaration 1:1. All the petitioners who completed the full-claiming test by 18/7/2019 should be given appointment.
Yes. Yes.
It is further next 28th paragraph is important. It is further submitted that TSHPDCL submitted a revised list of 856 candidates of in-source outsource workers.
Why there is submitted revised certificate? Revised submitted.
That is the big point. They, in fact, my lords, they are not supposed to submit any list after the notification. Only petitioner's application should be the basis for considering claim. Yet they submitted, their earlier list was considered, and entire selection process is completed. Now, after completion of entire selection process by 18/7/2019, TSHPDCL sent another list. What happens to the authorities, I don't know. On 14/8/2000, at least under what authority notification doesn't permit them to submit such a list to the NPDCL. Submitted a revised list of 856 candidates, adding 407 new candidates. Adding 407 new candidates. So the earlier list submitted more than 14 months back, my lord, that is 8/6/2018. On 8/6/2018, they submitted a list of 459 candidates.
Earlier submitted when?
8/6/2018.
8/6/2018, if I may interrupt. Sorry, my lords, I was caught up in another call. Look, just to recapitulate for 2 minutes.
Sir, I understood all the issues.
It is so simple.
If the respondent was able to satisfy me, according to me.
Correct. Our case is very simple. It's a 1:1 ratio. If it is 1:1, what does it mean? If I am selected in the 1:1 ratio, there is one post, you have called me. I must suffer a disqualification at that test, namely the pole climbing test. If you say that I failed the pole climbing on that ground, I am not selected, I am out. That is not their case. They come up with all kinds of arguments saying from some other district we got, there is no merit, there are more merit. There are more merit. You cannot say there are more meritorious people because it is 1:1. Therefore, the whole process is vitiated.
Yes, sir.
They provide a revised list on 8/6/20, 14/8/2019.
Includes 449 candidates again.
Yes, which includes the 449 candidates. That is furnished on 8/6/2018. That we are saying is improper. That's all.
Yes, sir. All are same.
See, the issue is the same in both these matters. I am leading in both the matters.
But, sir, just to satisfy me, whatever the actions taken place from your side after completion of the first selection list and whatever is not the issues in the notification, have you taken these new steps for stopping these petitioners? On what ground? What is the rule position? Under what sections or what provisions you did that?
Your Lordship may kindly take page number 14 notification. I'll start with number
14 notification.
in the red petition, my lord, it's fine. Page 14.
Oh, yes.
My lord, it is, we have notified about 2,553 post for junior linemen. Then date of examination is 8/4/2018. My lord, according to me, results were declared on 25/5/2018. 25/5/2018. Wherein, my lord, about
2018.
yes, 45,000 people have appeared for examination, including the persons who are working on outsourced basis in other power utilities. Then your lordship may kindly take to page 15.
Including persons
Who are working in other power utilities in Telangana. Fresh plus who are already working as outsourced person. Then page 15, clause 4, age. Then age relaxation. Age not below 18 years and not above 35 years as on 1/1/2018. Relaxation in upper age limit is permissible up to 5 years for SC, ST, BC candidate.
Yes.
Next is for in-service outsourced personnel engaged on contract basis, working in TS power utilities. As on the date of this notification, the age at the time of entry into power utilities as outsourced workers will be considered. So therefore, the contention of my friend is that I should not consider other power utilities candidates. But
I never said
that is advanced by my friend, Mr. Srinivas.
No. He never said anything like that.
So, for
It is on such an argument.
Outsourced and personnel engaged in contract basis, working in TS.
Yes, power utilities. Therefore, my lord, we have to take, my lord, candidates list from the different power utilities who appeared for written examination.
Some of my petitioners are from other utilities.
Power utilities.
Then,
Therefore, my friend Srinivas submitted that I should not have obtained the list from other power utilities. This is not correct, my lord. That's what he made submission this morning, just now.
Once read once again, sir. For in-service outsourced personnel.
For in-service outsourced personnel engaged on contract basis, working in TS power utilities. As on the date of this notification, the age at the time of entry into power utilities as outsourced workers will be considered. So therefore, my lord, to overcome that, because that if it is somebody is above 25 years, if they are already as outsourced worker, they will be considered, even though they cross 25 years. 25 years is the age limit is prescribed only for the fresh candidates.
But this action, when it has to happen before the releasing of the list.
No, well, I will come to that. Then your lordship may kindly see paragraph page 18, paragraph 6. The claim of the candidates with regard to the date of birth, education, technical qualification, community. Page 18, paragraph 6. that is subheading is important. The claim of the candidates with regard to the date of birth, education qualification, technical qualification are accepted only provisionally on the information furnished by them in their application form and is subject to verification satisfaction to TS and PDCL. Mere admission to test or inclusion of the name of a candidate in a merit list will not confer on the candidate any right for appointment. The candidate is therefore provisional at all the stage and TSNPTCL reserves right to reject candidate or any stage of selection even after advice has been made. So my submission is, my lord, at every stage the candidate is provisional unless he has been issued appointment orders.
Appointment will be only provisional.
Yes, sir. Repeat once again.
My lord, the claim of the candidates with regard to the date of birth, educational qualification, education technical qualification, and community are accepted only provisionally on the information furnished by them in their application form and in subject to verification satisfaction of TSNPDCL. Mere admission to any test or inclusion of the name of a candidate in the merit list will not confer on the candidate any right for appointment. The candidate is therefore provisional at all the stages, and the TSNPTCL reserves the right to reject candidate at any stage of the selection even after advice has been made. Then now your lordship may kindly take page number 23. My lord, the procedure for selection. Page 23, paragraph Roman 8. Procedure for selection. Evaluation shall be done as follows. Written test 80 marks. Then weightage marks for in-service outsourced workers engaged on contract basis working as on the date of this notification and who qualify in the written test 20 marks maximum as indicated at item C. Then minimum qualifying marks in the test as per rules. OC 40%, BC 35%, SC ST 30%. But this is the minimum qualifying marks. One may, in a SC candidate may secure 90% of marks, then he will be on the merit list. Merely because somebody secured 35 marks, he will not be called for poll climbing test because it is not according to merit. Then the eligible candidates will be called for poll climbing test in the 1:1 ratio, duly following the rule of reservation spirit of presidential order. The candidates who qualify in the poll climbing test will only be eligible for appointment to the post of JLM. Then B, the in-service contract outsourced workers working as on the date of notification in TS Power Utilities and acquired minimum qualifying marks in the written examination only are entitled to for the benefit of in-service weightage marks. In-service weightage marks will be given to the contract outsourced workers working in the TS Power Utilities in the following manner. 1 mark for every half year, that is 180 days. Any disruption or discontinuation of service for a continuous period of 180 days and above for whatever the reason as contract outsourced workers shall be considered as if fresh commencement from the date of resumption after such discontinuation or disruption.
Yes.
Then page number 24, clause G. The provisional selection shall be made at first instance, which shall be confirmed later. In the meanwhile, if any adverse information is received about the genuineness of document certificates produced, the provisional selection shall be cancelled without notice to candidate, but such information of rejection will be communicated. Now, from this, my lord, it is very clear that
With regard to petitioner, there is no.
but I am only saying about provisional selection. It is provisionally selected people, candidates only will be called for poll climbing test. Then, my lord, on 25/5/2018, after results were pronounced, we have called for the information from other power utilities, that is TS GENCO, TS SPDCL, and TS Transco. My lord, the candidates who appeared who are working as outsourced.
When the results is announced?
25/5/2018.
25/5/2018. After you call the.
Thereafter, my lord, the information sought for from the other power utilities, three other power utilities. Thereafter, merit list has been drawn. My lord, now my friend also read it. My lord, initially the TSSPDCL submitted a list on 8/6/2018, furnishing a list of 449 candidates. Then, my lord, the selection, pole climbing test was conducted in 3 phases, starting from 19/1/2019. Then second was in June 2019. And the last and the final was on 18/7/2019. Then, my lord, the TSSPDCL submitted a revised list
Three phases of pole climbing.
starting from 19/1/2019 to 2nd February 2019.
Third one?
Second, no, not. First is 19/1/2019 to 2nd February 2019. Second one is started from 19/6/2019 to 25/6/2019. And the last one was conducted on 18/7/2019. Thereafter, my lord, on 14/8/2019, 14/8/2019, which your lordship will find at page 11 for that additional counter, the TSSPDCL submitted a revised list of the candidates.
Additional counter.
Yes, that is on IA1 of 21. My friend read about military.
Yes. Yeah.
Page number, running page 114, paragraph number 8. It is further submitted that Telangana State Southern Power Distribution Company Limited submitted a revised list of 856 candidates of in-service outsourced workers who appeared in the written examination held on 8/4/2018 by their letter dated 14/8/2019, which includes 449 candidates list furnished earlier on 8/6/2018.
So the 856 revised list includes the 449 candidates.
Yes.
Who are the part and parcel which are
They were subjected to full climbing test.
in this?
Yes.
Yes.
Then in candidates list furnished earlier on 8/6/2018. In view of the revised list submitted by the TSSPDCL, the fresh merit list was prepared, and due to this exercise, names of some of the provisionally selected in-service outsourced workers were deleted, including a petitioner herein, and some new candidates were added in the select list depending upon the length of service they rendered in their company. My lord, I read to your lordship about the weightage of marks. The maximum of 20 marks the candidate is entitled if he is an outsourced worker working in any power utility. Even if it is in TSS and PDCL, he is entitled for it. Likewise, other 3 companies. It is further submitted that the newly added candidates were already subjected to pole climbing testing. It is very important.
Before notification.
Yes.
Before notification, when did you do it?
No, my lord, it has not nothing to do with notification. My lord, dates I am saying.
It is further submitted that the newly added candidates were already
Subjected to pole climbing test, they were provisionally selected.
No fresh flowing test conducted for them.
Yes.
So
now my submission is, my lord, all the newly revised candidates, they were already subjected to pole climbing test in the 3 phases. After receiving new list from the TSSPDCL on 14/8/2019, we did not conduct any pole climbing test for the newly added candidates. They were already subjected to pole climbing test. Only thing that their marks got changed.
when the pole climbing test is
They were there already.
when?
My lord, within in these 3 phases only.
3 phases only they
Yes.
are right?
Yes. It is on oath we are saying that we have not conducted pole climbing test for the newly added candidates. They were already subjected. Only thing is depending upon their length of service, their marks were added. Next paragraph, my lord. It is further submitted that in view of the revision of merit list, not only petitioner here, but some other candidate also fell out of zone of consideration. And the final selected list was prepared and appointment orders were issued on 6/9/2019 and completed the selection process in terms of notification dated 1 of 2018 dated 16/2/2018.
Yes.
So therefore, my submission is, my lord. Then page 117, my lord, I have submitted the list, details of the petitioners. Page 117. My lord, I said that total of 17 columns are there. The details represent petitioners are in developing number so and so by Sri Ramlu and 23 others. My lord, first petitioner. My lord, written examination, he secured 24 marks. Original weightage marks 13. Revised weightage marks 7. Total marks secured 31. Name of the last selected candidate in respective category. Column 13.
Result Q qualified.
Qualified. Then poll climbing dates and district of selected candidates 18/7/2019. Therefore, this is important, my lord. I submitted, my lord, no fresh poll climbing tests were conducted after 18/7. Of course, some of them we have conducted in view of the interim direction of the Honorable High Court. That is not subject matter of this writ petition. Then the marks secured by the last candidate 34, whereas petitioner secured at column 11 31. Then therefore the selection.
No, what is this? Total marks after revision 31.
31.
Marks secured by last candidates.
My lord, in that particular category, the person who was selected last, like my lord, petitioner is a ST, first petitioner applied in ST category. Then in that ST category, my lord, the last selected candidate secured 34 marks.
Oh.
Then like the second petitioner.
Means after adding this, your
Yes, after revision.
After revision.
After revision, in view of the list
Submitted
submitted.
of another 448 members.
Yes.
This person got 34 marks
Yes.
and 31 is first candidate.
Yes. Therefore, your lordship may kindly appreciate one aspect. Once again, I am submitting that after 18/7, we have not conducted any fresh poll climbing, though we have received a revised notice, revised list. They were already subjected to poll climbing test. In fact, the first petitioner, again the first petitioner, the selected candidate was subjected to poll
Sorry
climbing.
to interrupt, my lord. It is not my case. I don't know why he is saying this. It is not our case that after the selections were over, you conducted a fresh poll climbing test for us. Our case is we are the only persons for whom poll climbing was done. It is 1:1 ratio. If the moment I come, I do a poll climbing, my provisional certificates are there, you test, I get a job. And today he comes up with a new argument saying, for the others, we never conducted a poll climbing test, but we selected them against these people.
He's telling they are also participated in poll climbing.
No, he's saying
3 pages.
on those 3 days we never conducted for other than these people. Whereas in this merit list he does not show it. That poll climbing test was done on those days.
Column 13, column 12, my lord.
This is of our selected candidates, not those candidates.
You have any proof, sir?
My lord, I have submitted this.
Say suppose for the newly added member. When
My lord, an affidavit on oath is said that after 18/7/2019, we have not conducted.
Poll climbing.
That's what I'm reading, my lord. That's what I'm reading.
He's saying not conducted.
What I'm saying is, my lord, after revision of the list submitted by the TSHC, we did not conduct fresh poll climbing to other persons. They were already subjected to poll climbing.
When?
They were zone of consideration.
When means he is telling those 3 pages they were conducted.
They were already there in zone of consideration.
For that, show me one evidence.
My lord,
My lord,
their cases, my lord, please see their case. Their cases, these people conducted our poll climbing test.
Great respect.
After, okay,
Entitled for my submission, my lord.
Fine.
Sorry, sir.
I interrupted because that is not our case.
Yes, okay.
But the case of the petitioner says, since they were subjected to poll climbing test on a particular day, they qualified, they should be given appointment.
Simple.
What we said is, every stage, all the candidates were provisional. And when we draw the final list, because of the revision list submitted by the TSHC and they were subjected to poll climbing test within these 3 phases, therefore their marks were added or deleted depending upon the.
Where you stated these the
Milord, that Milord, I have
No,
given
what
a
you
statement.
said now, where you stated that conditions.
Milord, condition I read out, Milord, the in-service candidates are entitled for marks.
If they are applicants.
They were applicants.
Where?
In service, all this, therefore I submitted.
You complete your argument, then we'll come to again.
Yes. The name of the last selected candidates in respective category is one name is given.
No, this is Jato Sridamli is the one of the petitioner.
Yes, ma'am. First petition.
So he
First
got
petition.
31 marks.
He got 31 marks.
After adding the list, the other person got 34 marks. So that is the
Correct.
reason he was not selected.
Yes.
According to this list.
Yes.
For my understanding, I am.
Yes, that is
correct.
Next. So you prepared this entire 25 members.
yes.
Who are the petitioners in the writ petition?
In fact, Milord, it so happened that when the matter came up before another learned judge here, I was directed.
According to no one is qualified.
No, Milord, they fell out of zone of consideration because of the revision of the list. Because of adding of the marks of the persons who were selected. Not only the petitioners, Milord, some other also, like fresh candidates.
My doubt is,
Milord.
initially you issued one provisional list.
Yes.
So why you have not issued the provisional list, including this initial stage?
No, Milord.
Tell me that.
Milord, I may clear myself 1 second, Milord.
Once you pronounce the provisional list,
Yes.
after that, some of your authorities recollected the conditions, etc., then you stop that and you revise another.
No. Milord,
How
some,
you proceed?
my submission in this regard is that.
So clarify this doubt.
Very well.
Once you read the list, provisional list of candidates, why you have not at that stage all these new persons?
Milord, these
Who prevented you?
Those who have been subjected to poll climbing test in all 3 phases, they were provisionally selected. All of them.
Yes.
Milord, what happened? We started poll climbing test on 19/1/2019.
I am not asking that question of pole climbing. After completion of pole climbing, you released one list.
No, we did not release any list.
All the petitions.
No.
That list only, na?
Milord, the list was prepared before only. Accordingly, we have called for the poll climbing test into 1:1 ratio. Then what happened, Milord? 19/1/2019 till 2nd February 2019, there was first phase of poll climbing test. In those,
You have any record these added list of persons participated in poll climbing in so and so days out of these pages? Official record is there to that extent?
Let them produce that.
Yes.
Of the poll climbing of the other candidates, let him produce.
For the newly added list, produce that list. We can consider.
I'm sorry, Milord, may I just 1 second? I'm sorry, I could not get it. The last is directing me to produce what?
The
Poll climbing test of the other
added
candidates.
list persons when they participated poll climbing test. Is there any official record is there? Not this tablet form. For that you prepare some climbing test. This person on this day, this person on that day. And
Of course, while
you produce that
issuing call
record,
letters,
you
Milord,
fill
there will be a list. While issuing call letters, there will be a list.
So produce that list. Produce that list. Then you can, what sir?
Yes, ma'am.
Now that
My lords, let him produce it because our case is all, if your lordships kindly take, let him kindly take up their own counter.
If you don't mind, sir, I'm projecting that regard, we'll start again.
Yes, all right. But let it be a short date. I think your lordship are the 8th judge hearing this matter.
I think I heard this earlier also in that.
Correct.
Benches, sir, was there and now I had as 8.
So I
In
want.
fact, Milord,
So
Yes.
minus 5.
friends,
So when do you want records?
I have been requesting.
Wednesday or Thursday, my lord.
Thursday you are able to produce?
15 to 16, Milord, I may not be available. Milord.
So we'll.
17th.
18th, 18th, I think there's
No, Saturday, I'm.
20th, your lordship.
Okay, post on 20th. 20th.
I'm sorry.
Doing your job just as badly as I'm doing mine.
Sir, we will complete the case this court only. So
Yes, yes, sir.
you put in that record. We'll
20th.
see.
Obliged.
Sir, sir. Huh? 2:30
Read, they are requesting Wednesday, sir. They are requesting Wednesday.
My practicing position
They want to take another half day for arguments. So that's the reason they are asking time. What do you say?
now it requires Milord, now the argument, the crux of the point is very simple.
No, sir.
Appointment is made.
Now the case was I heard now earlier.
No, I see. Milord, our experience.
Arguing, I convinced them.
Now
And second time again, start respond again. So
Now,
small case, small point. But according to them, another issue is involved.
Milord, the performing is very, it is not an easy task. Your lordship has to see and ensure.
Sir, what do you want to tell me? They are asking. Any Wednesdays?
Do any, but it should be positive, Milord. I have been exhaustively, Milord, tried in this case.
The senior account auditing, you are telling they taking time. No,
And,
you give the date and that day you complete everything.
Well,
One sir.
my appointment has been made on zonal basis. Now you can't prepare the interstate seniority of Milord district cadre. It is unknown to law of service jurisprudence. Once you appointed, according to the norms which was prevailing as on the date of appointment, you can't circumvent with regard to that position and making into the preparation of the seniority, depriving my higher opportunity of promotion. The persons who are appointed after 10 years, they are being provided,
Wednesday you want? Wednesday. With post on 15th. Finally.
Kindly pass out only.
Pass over.
Issue is appearing this matter.
Who is appearing other side?
So this who is appearing, Lordship?
Item 62. Ready?
Lordship can be taken up next week, Lordship. The law and GP will also be present.
It's easier until now.
No. Let's very pass over. When that also they will take time again pass over. That's what initially I am asking to them.
This is regarding consolidated pay, Lordship, wherein the outsourcing agencies should also be
1
included.
week you want? 1 week you want?
1 week, Lordship.
Okay, 1 week post after 1 week. $60.
269.
Petition needs ordered, the incomplete petition is not ordered. The,
what petition is not ordered?
incomplete petition.
Who filed incomplete petition?
Milord, in fact, my friend has filed. I filed. But the, where in all the writ petitions, they say, but incomplete petition is ordered, even the one writ petition, that is sufficient.
Right. And actually, Milord, so there is a, looks like there is a problem because no, it was ordered earlier. Therefore, only after that only we served the notices. But it looks like because no, PV Ramana didn't get that one. So therefore, if at all, if it is not ordered earlier, kindly order the incomplete petition. And everybody's name is printed except to PV Ramnagar. So that is, there is a technical.
Want to advocate names, you have to say the code numbers also. But here the complete petition order got that, what was told?
No, no. That was.
IA 1 of 2023 has to order.
Okay. In those, yes, 5239. It's only.
5239. Okay.
Yes.
Complete petition ordered 1 of 2023. Reasons stated by the petitioner satisfied. Accordingly, the IA was allowed. 1 of 21. After 1 week or 2 weeks? Okay, next post after 2 weeks.
My lords, I mean, Ramana garu mentioned to me that no 21st or 22nd, that would be feasible for him.
22nd.
Oh, bless.
Post after 2 weeks. In the case post after. Yes. It is in a course option post after 2 weeks. Same post after 2 weeks. Next week, 73. Post after next week, 73.
72 million.
Oh, no, again to next week. Yes, next.
72 million.
72 of 2 weeks.
In that case, Millard, in the already interim was the order was there, Millard, consider representation.
You are for the petitioner?
Yes, I am for the petitioner, Millard.
So nothing survives?
Nothing survived, Millard.
You have the interim order, no further orders are required, hence petition is closed.
But they are considered or not, Millard, they are not passed any orders on the representation.
Then, okay, we'll see. Who is Tum Srinivas? Is there anybody?
May I please, my lord? I'm in the line.
consider the
My lord, as
representation?
per the interim order, my lord, we are considered and given all benefits of the petitioner, my lord.
Then it's closed.
Yes, my lord.
Okay,
That
let
may
the
be
counsel for the
my lord, I can-
petitioner informed this. Yes. duty for services 1 is there. 2. Item 75.
We will be needing weeks because we don't have hours.
Post after 2 weeks. None of this post after 2 weeks.
That is about the differential amounts of gratitude to be paid to the petitioners. They are 6 in number. They have all retired.
Who is appearing other sets?
He has filed the. I have also filed a memo as to what are the amounts to be paid to them, differential amount paid to them.
Paid already?
No, they have paid not the extent of government order. But the government order is 12 lakhs is the higher limit for gratuity. They have paid us only 10 lakhs. Differential amount of 2 lakhs is to be paid. This 2 lakhs is according to their the salary drawn and other things that are to be calculated. Now with the point, one point of time, what he said was that you have to make us some calculated sheet, give us sheet, so that what is the differential amount that are to be paid to you.
Submitted that.
I have submitted, it is also there in the memo.
What is that?
And may I make one? They have themselves in the counter admitted that the government has increased this amount, and the corporation has also resolved to pay that amount to them. Only thing is that there are 5 of their counter on page 3 for a moment. This would clinch the issue. Paragraph 4 is that the government has enhanced it. I submit that with regard to government's meetings also, it is true that the enhancement of maximum limit of retirement gratuity 12 lakhs was placed before the board of meetings also. In the said board meeting, it was resolved that the benefit of maximum limit of gratuity is extended to all the employees of the corporation effective from 15/4/15 since the date of incorporation of the corporation. After bifurcation of the state, but Telangana State Agriculture Corporation is again incorporated from that date. We have and it is this enhanced amounts are with effect from the incorporation date. The lordships can see this effective from 15/4/2015. We have all retired after that. So we are entitled for that.
So you are all retained from after 15/4/2015.
Yes, I have given a statement of this on page 3 of my affidavit. But the respective dates are given below. It is 16, 16, 16, 17 and 17. Paragraph 3, affidavit.
The affidavit, sir.
Yes, madam. Paragraph 3.
Yes.
So respective dates are given. They have retired, and then whatever their last pay drawn, and according to last pay drawn, this is to be calculated.
The corporation effective from 15/4/2015.
Yes, madam. We have retired later to that.
After that only you retire.
Yes, yes. Therefore, we are entitled for that benefit. Paragraph 4 of their counter says that it is resolved to extend this benefit to all the employees. And that, but the effective date is from that date. That date is after this date is before our retirement. Because we have retired in 16 and 17, we are entitled for these amounts. And having said so, what they would further say in paragraph 5 is last but one sentence further from down below in the 5th paragraph. Further the petitioners ought to have made a representation that this is what they stand now. Application in terms of gratuity act for payment of enhanced amount and it will be without following the said personal procedure and rush to this court without any case. As admitted, the corporation has paid the amount to the petitioner as per the entitlement on the date on which they retired service rules. As such, the present petition is not maintainable in law and petitioners fail to make any case either so also. As such, no repairing. I also respect submit that if the petitioners feel aggrieved that they are entitled for enhanced amount, they may be directed to submit the application to the first respondent herein in terms of provisions under the employment under the payment of gratuity act. I have said representation because at this point of time earlier with the honorable bench after seeing all these things, they have directed him to file a memo as to what is their entitlement. But I have filed a memo now. Kindly see the memo. But as per this memo, yes, sir, number one. This is కాదు మెమో ఫైల్ చేసావు మెమో ప్రూవ్ సర్వీస్ కాదండి మెమో ఫైలింగ్ డీటెయిల్ స్టేట్మెంట్ ఆఫ్ దేర్ ఎంటైటిల్మెంట్ ఇట్ ఈస్ సబ్మిటెడ్ ఆన్ 6/11 ఇది తీసుకోండి ఇది ఇచ్చేస్తాం దిస్ ఇస్ ద డిఫరెన్స్ yes sir number రాశారు వెనకాల Lordship can see by this memo, the statement is given. Details of retired employees of so and so, enhanced from so and so. So their respective enhancement balance dues are mentioned in the last column. So these are the amounts that are to be paid to them as per their own agreement, as per their own admission, and as per the resolution passed by them. Surprisingly, the corporation also passed a resolution saying that it should be paid to them. I also filed a copy of the resolution that they have passed. Along with the counter, they have filed it. I also filed along with my writ petition.
2016-17 retired. 2015 corporation bifurcation. 16-17 is allocated and what decision was taken in 2018. He was directly questioning the GO and filed a writ petition. They never approached the court. They are ready to pay the amount the board issued as 2018 financial education. The taken decision. Already 10 lakhs is received. Earlier, corporation 3 lakhs to 10 lakhs enhanced. After that is the condition, they are received the 10 lakhs. The state bifurcation, the government issued a GO, they were 10 lakhs to 12 lakhs.
Enhancing the
10 lakhs to 12. Every person not to 12 lakhs. The date of appointment, the variations of businesses, they can ready to pay the amount. The condition is also the variations and interest for them. And ready to pay. One sufficient. I'm ready. The difference is according to difference. That is the reason I will submit the dispose of the repetition. The condition is similar. Is direct the repetition at the prayer is tomorrow. Every person conducted the according to this.
First case 1,45,000 according to them.
Difference is
1,36,519. Second one is 1,90,000. Yours is 1,01,000. Third one is 20. This is high 45,000.
That is the reason, Lord. Go and update the authority.
This is the half.
How many amount is claimed? I am ready to pay the enhancement financially.
Why did you accept this, sir? Even otherwise, if any grievance is there, in calculated again.
That is the government is ready to pay amount. Today. That is the reason I am going submission, Lord. Go and approach the authority whenever amount is released.
Now that they have come forward to pay the amount differentially. Only thing is calculation. They calculate some, then we have to calculate something. Let this be sorted out by them. We go and approach them by filing both the things before them. Let them decide it. Let them decide. It's a plain time frame. That is what I request. Sir.
Yes, no. One submission, Lord.
Without going into element, simply I will pass one order. That's all.
One submission.
This thing that has to be retired for not to start. According to DO 9, it is enhanced to 12 lakhs. According to the resolution passing, they have agreed to.
They agreed. One complaint. One submission, Lord. The prayer is the problem is the prayer is moral. 99 GO is continued. Otherwise, the honorable court was directed the according to GO disposing of the petition. Every person come to the High Court and so and so GO according to 2 lakhs to 12 lakhs is claiming. That is my difficulty. According to his calculation, my calculation calculated the
Petitioners filed the case to settle and pay the entitled different gratuity amounts to the petition in terms of the GOMS number 99 dated so and so. Yes. After filing of the writ petition, the respondent authorities came forward certain tabular form, whatever the amounts due to the petitioner. Yes. And directing the petitioner to approach the authorities.
Yes, ma'am.
Whatever the amounts are due.
Yes,
according to them.
They can ready to pay the amount within 8 weeks or 4 weeks. Can you do?
They don't have freedom.
Yes, that can be done, but my memo can be also recorded.
Yes, yes.
My
The writ petition is filed.
Millard, one submission. Memo is the interested is also collected. This is not a gratuity amount.
No, observation.
Much.
It's filed. You take whatever action against them. Take. I have given time next week. Twice I asked the petitioner respondent counsel, are you informed the council or not? Yes.
Me for tomorrow.
But that they didn't say that.
No, another AGP didn't present here. Another AGP presented. That is the difficulty.
What can I do? I already adjourned, already drafted.
1 week time, yes, sir. Lordship, 79 and 8 months.
Item?
79 and 8.
79.
Yes, no, next matter. Taken up Tuesday, Millard.
79 and 80 both matters.
Yes, 80 how to get instruction. With the pass of this one.
Tuesday. Post on Tuesday. Yes. 83.
4 weeks, Millard is too long. 2 weeks, Millard, they want to file a counter, let them file it.
Post after 3 weeks. This I don't understand.
Item 5 has been passed over.
Passed over item, Millard. Synopsis was supposed to be filed.
Filing synopsis in.
I'm filing the synopsis.
About correct. Ready with this.
Yes.
Already my lords have heard the arguments in this.
Yes, yes, yes.
Delayed.
Password.
Pass,
Password.
password it is.
Only password.
Oh, bless.
What about Mr. 3? Basing on the interim order, medical examination was conducted. Not item 3. Sorry, the item number 3. Okay. A number? What relief we are seeking from this court now? Only now the question is only with regard to interest only. Additional లేదు నాన్న. Additional is not available. Declaring the action of the respondent withheld the payment gratuity of the petitioner's father from the date of death of the petitioner. Father dated so legal. Payment of gratuity pay cheyaledu, only interest. Gratuity paid. Okay. Where is tribunal award? Pay number 5 of your additional material paper. It is not there. What is that you read first? Yes, that's what I'm thinking. In the main prayer, Mr. Counsel, just you are seeking gratuity of the petitioner father from the date of death of the petitioner father dated so illegal, arbitrary, and contrary to the provisions of the Underpayment of the Gratuity Act, and they settle the principles of law laid down by the Honorable Supreme Court, consequently direct the respondent to pay the gratuity with interest. How much interest you granted? What is there? They are saying as per the tribunal order, interest also calculated. That's what we have. We don't have that additional material paper. Page number? Yes, amount of gratuity is 1,08,081. Interest payable 10% per annum. Uh, uh, uh. What is this, sir? I am not able to understand. One lakh 8,081 amount of gratuity. Already deposited with controlling authority. Clear. Yes, sir. Fault is not them their side. Fault is in your side. No one is appeared. Whether withholding of gratuity by the respondent company is justified, whether the applicant is entitled for the interest in the delayed period for unpaid gratuity amount or not. Yes. Here also it is there. Payment of interest is exempted only when the delay is an account of fault of the employees and the employer obtains permission of the controlling authority for delayed payment. No, that's what the second issue only I am reading. So depositing of the amount is not delayed by the deposit. Nobody is appeared, nobody was respond to their letter notice. What is it, form R? No, sir. You will not get the interest as per the observation of the appellate. Where? There was no provision in the Act for payment of interest when the same was quantified by the controlling authority and before the collector was approached for its realization. If amount of gratuity payable under subsection 3 is not paid by the employer within the period of specified subsection 3, the employer shall pay from the data. But here that is not the question. They are ready to pay. No one is approached them. Show me within the limitation period, we approached the authorities, they have not deposited. Show me one evidence, we'll ask them to pay more interest also. Yes, everything is same. If any fault is there from their side, you are eligible to get the interest portion, but there is no fault of them. When you made an application, when they have to deposit it? Yes. But the stipulated period, you have to deposit the amount in the bank. Even nobody approached you. As you stated in the conditions of the family, I think no one will approach. Why? Because both are died or my children are very minors. Where are you reading? Already I have read in there. Bank to pay the interest of the amount. Bank was not paid any amount, interest amount to you, Mr. Counsel? Yes. No, you clarify me. Actually, what is the stipulated date to deposit the amount? From the date of application. What do you say that side? That is the crux. No, when the petitioner was died, 13/5/2005. When the amount was deposited, 5/12. When they have to deposit actually? Is it so? If they make application, but then show me provision. If they won't make any application, the department has to deposit the amount. Show me that provision, I'll ask them to pay interest. Any interest was given or not basically? Oh, I'm asking. Say suppose tomorrow they will make an application for interest person. Are you ready to pay? You withdraw the amount from the bank, sir? No, they have to pay interest. That is the direction. You have seen the article. No, correct. But interest person see. Then bank has to pay. That is the direction here. Order. Therefore, in view of the legal position and also factual matrix referred above, I hereby order the respondent bank. Respondent bank made party in this writ petition. Huh? Where is respondent bank? No, you are not made the party respondent bank in this writ petition. It's the council. What? You are depend upon this order, na? But order what they are saying, interest portion, the final order, read once, page number 4. Last but one paragraph the order. Therefore, what it means? How many days is asking interest portion, sir? 209 months. More than the gratuity amount. Okay. Check your luck next date of adjournment. Or I'll pass orders, no need to pay any interest. As per the order only the bank, this one. Pay number? 1,08,081 rupees. To CH Manohar, CH Madhukar Rao, Srimati Mamata within 30 days. Oh, instead of respondent, bank was typed. But which bank they deposited the amount? Amount will not be there within the respondent authorities. Na? They will deposit to some other bank. Some bank they will deposit. Na? Then you are telling typographical error. Instead of authorities responding to the type of bank. Correct, sir. Yes, 29/10/2019. Oh, you are not clarity. You are not giving some clarity, sir. Come again, we will see. You not file counter. Huh? Then if you are not file counter, then clarity is given the clarity. What is there? He is asking. What is the clarification? There is the matter then. Post after 2 weeks. Admit avaleeda? Okay. Rule is post after 4 weeks. What about 4 Surendra Reddy? Tomorrow. Tomorrow, sir. Yes, sir. Give me. Sir, circle this one. Already given, huh? So, okay. This is January 23, 1991 circular. Yes, such request. Within 5 hours of date of joining service of the corporation. So 1979 to 1999. What are you doing all these days? 30 days, 30 years, 79, 89, 99. Okay, 19 years. You are kept silent. So when you are retired from service, 2017. No, retired from service. 15/8/2017. You are retired from service 2017, madam. Now we are in 2023. Yes. So all these exercises done within the period of before the retirement only, madam. After retirement, how you make this application, etc. How they will appoint you after retirement. And you, I think, as per his information, you did not oppose the any benefits. Everything was taken without. Where is that 2000? 1 second. వాళ్ళది పాపం అలా హోప్ పెట్టేసరికి మళ్ళీ మీకు ఆశ చివరించాయనట. But you are not opposed while getting the benefits, madam. You didn't say anything. No, while getting the benefits from the authorities, without opposing anything, you are accepted everything. What it means? Even that time also he don't know, being a driver. After getting promotion, clerk, etc., also you don't know. While this type of allegations are there, with regard to the when is the first application? First application for change of date of birth. 8th February 1999. Yes. These rules are retrospective or prospective? When the circular came? (1991). The first representation after that circular only. 99. That is the 47. What is the reaction? Huh? 55. But after so by letter sold to 24, chief manager PN also. Basic. Quote. 1 second. Where are they in this bundle? No, booklet ఇచ్చినట్టు you are given. మీరు కాదా ఇదా this one this one. Yes, 11. 1 second, madam. 1 second, madam. 1 second, madam.
The even concrete
Where? Yes. Yes, we'll see all the facts, madam. Okay, heard both sides. Is that? Yes, we'll see all aspects, madam. Yes, we'll see, sir. Yes. Yes, yes. We'll see all these aspects, madam. Yes, yes, yes. Yes. What do you say, sir? Covered order కాదు. Counter is filed, huh? What do you say in the counter? Minor. So you want to argue the matter on merits then? Modified without cumulative effect. What else more you want again? So you relief only to that extent only. What is it, sir? But it's not censored, no? Yes. So, modified as without cumulative effect, huh? Ask your authorities will reduce the punishment. What is that you are reading, sir? Where? Page number? stoppage of two increments with cumulative effect to minor penalty, that is stoppage of two increments without cumulative effect. Yes, what do you say about with regard to 18/5/2008 circular? You get clarification with regard to this, mister. I'll post the matter next week. Page number 35 of your counter. What is your action with regard to this 8/5/2018? How you stalled even though this letter is there? Huh? Okay. Okay. Anyone next week? Okay, post next week. You get that clarification, sir, so that no, you implement that your own letter, sir. You have to say something against your own letter, isn't it? You have to say something with regard to your 18/5/2018 letter. Hmm. Ready, sir? Both of you ready? What is the matter about? Simply tell me. 1 second, 1 second. This minute. So if it is sanctioned post, you will be regularized. Yours is not a sanctioned post. Show me one evidence. Yours is a sanctioned post. Your appointment is against the sanctioned post. Show me one evidence. Then Then what to do? Tell me. Sir, sir, rules are stopping you to came forward. What I have to do? Tell me first. Rule is that if your appointment is against the sanction post, as per Umadevi case, you have to regularize services. But your post, tell me, you are the answer. You have the answer with you. Tell me what is that answer? Who is appearing for director? Correct, sir. How to clarify it? According to you, you are not appointed against the sanction post. For that, show me only evidence if you are so. What is this, madam? You get clarification? You have an appointment order or not? No, show me, mister. You don't have any appointment order. No, for any even sweeper post also, attender post, they will give some appointment letter, na, sir. You have the copy with you? No, you don't have any record with you. So how you have to believe, madam? One side you are saying he is not appointed against sanction post, he is saying appointed. How to get clarification? Both of you tell me. Yes, show me that. Post after 2 weeks. Yes. Okay, next week. Yes, sir. What is the matter about, sir? No issue. What is this case, sir? You are going to compassionate relevance pension. To that extent, you got any order from this court? What they said in the counter, sir? Show me this one. They served to you. Yes, correct. Yes, sir. Thirty-five page number is there, 34 is there. I impose the penalty of reduction of basic pay by 2 stages is the time scale for a period of 2 years. He will not earn any increments to his pay during the period of such reduction and on expiry of such period. The reduction will have the effect of, what is this? This is a 34. Yes. Yes, yes. Why don't you think that's it, sir? You pay the compassionate allowances. Where is the representation, sir? Two 2015. But which date you are submitted, sir? 2015 is that month. Date is not there. Where you are extracted, sir? Yes, yes, yes. Compassionate allowance. An employee who is dismissed or removed renewal from service shall be forfeit his pension, provided that the authority higher than the authority competent dismiss the remove from service. The dismissal removal of termination is on after the 1st November, 1st 90 In the case of deserving of special consideration, sanction, the combined allowance not exceeding 2/3 of the pension, which would have been available to him on the basis of the qualifying service rendered up to the date of his dismissal, removal, or termination. Yes.
India, the most conservative.
Yes.
Yeah, that is the first one. This is the entire family will be backward. There is nothing to call that. So, the bank here, because they have considered the application and asking to approve this, of course, but granting of compassionate evidence. Unfortunately, the bank is the part of here, and you and giving the compassionate elders. He has undergone tests. You have never been taught the dumping doctor.
Yes. What do you say, sir? Only thing I'll say from this court, the one thing is clear, both the officers involved in the incident, both are not punished equally. Some discrepancy is there while punishing the authorities. Number one. Number two, he made an application. He's not asking any other than remove, reinstate or everything bond. Basing on his family background and the financial condition of the family, he made a request to apply the regulation 31 to get out of his entire issues. Why don't you think from that side in a positive manner to settle the issue once for all? Yes. Oh, no issue. Achha. Okay.
What is that is that he and the taking Mr. Bhaskar whose punishment are just not. They are the joint custodian of security documents.
Okay.
So the Bhaskar law is endowment. He is also supposed to supervise them. These are record only the gentleman was released because the camera in which we see documents, the bank forms, kept in the bank class. They hold the drawing. These are operated with the offices. Nobody can open it. But what we of that sparrow he played another part. That years back, order in place other we became fine. That is subject whether what participant I respect something. Accidental. What kind of punishment?
Correct, sir, but
But yes. I think that I will not
yes. story. Mm.
What? What's that? What's it? Is that? Yeah. What's that fire? But it's means that the government is using dishonesty was the fire. Such a sincere. These two are much
No, the 1 second, sir. What are the documents in the under custody? How he misused? For my knowledge, I am asking. DD. Okay. All blank demand drafts. Okay. Give it to some other person by way of DDs. On the check, on the DD, both signatures will not be there, only one signature. These two officers' signatures will not be there, only manager's signature will be there on DDs. Yes, yes. Yes, sir. Yes. Inquiry, which page starts, sir? Inquiry report from page 12. In the Evidence Act, which section you are referring? 41, 40? 73. Yes, okay. Yes. Yes, sir. Heard both sides. Reserve. If you want, I'll give 1 week time. Consider case some extent, not full extent. Compassionate allowance. Say suppose under the compassionate, how much you will get? So 50% of the compassionate allowance. Yes, it's correct. One way is no, you are not the person. The only thing is extreme in personal view, in my personal view, forget about all the issues. Corruption of 1 rupee, 1 crore, both are equal. The punishment is, but the thing is attitude. If you have able to take 1 rupee from the counter, tomorrow he may take 1 crore also. So attitude indicates the mindset. That's my personal view. No, some of the, just for relaxation, I am asking. Somebody made a call to me. 10 lakhs తీసుకున్నాడు 10,000 కి ఏమైంది అంటాడు. 10 lakhs 10,000 ఏందిరా బాబు, 10 కాదు 10 రూపీస్ తీసుకున్నా అవుటే. When I was practicing as an ASD, somebody, Anna, they are getting crores of rupees by way of this backdoor method. This person take just 10,000 only. Are babu, 10,000 to 10 crores kaadu. 1 rupee is also, that's attitude indicates the thing, entire thing. We can't consider, but only thing is observing the person's, the family condition. I asked you on the earlier occasion, if yes, heard both sides. These are evidence will. Give it to me, that copy. You have the copy with you. Yes, sir.
Yes, yes.
Okay, we reserve it. We'll see this. Reserve it. Next. Anybody is there? Both sides. 80. G. Rajesh. Will you close down? Why? No, so on that it's not, case will be closed. Where is he, Rajesh? Okay, we'll have it day after tomorrow. Day after tomorrow, Monday, or Tuesday. Madiraju. Okay, post after 2 weeks.